requested this money. We were doing 16 I was to show you the numbers, 16 training reporting. I have written NDPS service. Okay. Where is this?
I beg to mention,
Yes.
13 minutes. 13. This content matter, madam. Today morning, my learned friend, madam, find and reply, madam. I received, madam.
What is it?
Madam?
Complaint.
No, madam, not.
Have you complained?
They are not. I'm responsible.
Okay.
So, madam, they filed today, madam, according to the last document, they took break for time, madam. Today, so they filed affidavit, madam. Reply, madam. So, they will propose, madam, this method will come.
Content, either there is a compliance or no compliance.
No, madam, there is some, we have filed on read petition also, it is item 24, madam. It is there, madam.
No, read petition is something different.
Yes, so it is really related to the same subject matter, madam.
Can it be clubbed together?
Yes, not club, but it is same subject matter. We have select not in registration, madam, this order of the district deputy commissioner, this Dimapur, madam. There is an order of this division bench as well as single bench, madam. The award was which was passed, madam. We have to select before the appropriate authority as per the statute, madam. And now, madam, we have select. It was select before the yes, madam.
Section 12.
Yes, madam.
Under 60.
Lordship in so far, yes, ma'am.
Yes, madam.
Reference.
Yes, madam. Reference.
There's some reference to the civil court, madam.
Yes.
That was rejected by the deputy commissioner.
Yes.
In so far as that, madam, that is item number 24.
Yes.
So Lordship, let that matter come up, because madam, there's a statutory bar. The beneficiary or the government cannot seek for reference under section 12, madam.
My lord, I only one day accommodation I put it, madam, in that case also, madam. One day, today.
Next week.
Next month on 10th of
Monday.
My lord,
Monday. Yes,
my
ma'am.
lord, Monday, my lord, I actually am central government.
Tuesday.
My lord, 10th of
Thursday.
10, madam, 10.
Friday, even Friday.
Friday,
Only we'll take up this matter on Friday.
Friday, which is there?
Make it Thursday. See, your challenge is
Yeah, I know, my lord. But
repetition is something different. Contempt, whether only we have to see whether there is a contempt or not.
Yes.
which one, my lord?
Whether you have complied with it or not, that we'll see only.
Yes, my lord, the contempt matter is that, my lord. So
That's what I'm saying.
my lord, the other, the responsible 5, 4 and 5, my lord. Only the guy is appearing, my lord. See, my lord, accident, there's an accident, my lord. See injured, my lord. See, prayer, my lord.
Thursday.
On
What is the Thursday?
10,
Thursday.
10, my lord, 10.
10?
of October, my lord. But,
Thursday.
Thursday, my lord, I have a case in fix and test court, my lord. So, 10, my lord.
Friday. For you, it's like on Friday.
My lord, this already some cases, my lord, isol bench also, and internal also, my lord. So,
See, then we'll take up today.
Yes.
What is there?
which one, my lord? Contempt, my lord.
Contempt, yes.
Contempt, they filed today itself. The other two respondents. Other two respondent, the advocate is there, madam. They people security and honor again.
What is your stand?
This so far my the respondent three, madam, I sent a letter to the respondent 1 and 2, madam, to comply this order, madam. In this case, madam. In other one respondent 1 is madam, defense secretary, madam, and 2 is the director general of border order. Their stand is different, madam. Their stand, madam, is because of this. There is the order of this honorable court, madam, and state. We have filed a case before the district collector, and that was my lord dear. So they are not agree, madam. So I am not. I am only respondent 3, madam. So today they filed the affidavit, madam. So only the 10 days, madam, the accommodation is required, madam. Last one. Yeah, 10 October, madam. He also in the agreement.
I can
Because madam, nothing will happen, madam. 10 October, madam. 10 October.
They said you have agreed.
10 October.
That is regarding the inside outside the court.
Yes.
Saying one of his colleagues met some accident.
It's okay. That is
Madam, the last.
he's so adamant.
No, madam. Actually, I'm.
Actually,
I have one instance regarding central government.
regarding this content matter, madam. Since one of the counsel has met with an accident, that's what I was informed by him. So therefore accommodated. But regarding item number 24, madam, let that be heard today.
My lord, only one day accommodation, my lord, I said, madam. Because my lord, this.
Why?
This is
Why there is a Supreme Court list?
Because we have this one is
constant. This is content second number 14.
No, I am told you have been supplied with a different cause.
Oh, Lordship, yes.
So that you should come with total confusion.
Okay, this is, okay, no, this one.
This is also
25. Lordship, yeah.
24, 14.
14.
this is 14,
Yes, this is 14.
not the.
Yes, my lord, I've got this.
It's okay. Then in that case,
Lordship, regarding to the seat type, Lord, when it come up today.
My lord, the same, my lord, the documents I require, my lord. This is for end of justice, my lord.
She's not there. Other council.
I-
Only he's there.
My lord, there is same subject matter, my lord, on the case.
It's not same.
Court will come back.
Lordship,
Then down that there is a complete disposal of this, whether it is dismissed or dismissed on the end of the document.
which one?
On 20, item 24. So
25.
24.
You are making an adjournment
24.
of 25 also.
24.
it's 25.
Where have you filed a reply, counter affidavit?
No, not yet.
No, my lord, not valid.
So we'll see 25, we'll see, then see, content will fix it on 10.
Content is okay.
Okay. Heard Mr. So and so,
SK, my lord.
SK Medi, respond number 3, and also her empty long, learned counsel for the petitioner. On the prayer of Mr. SK Medi, learned counsel for the respond number 3, list this matter on 10/10/2023.
You see the everyone, we have each
Huh?
1 and 2, my lord.
Who has to comply?
Comply, my lord, 1 and 2, my lord.
You are for 1 and 2.
My lord, this is senior, my lord.
Huh?
Each Chakraborty, my lord, is system.
Okay, we expect that on 10th of October,
Yes.
you should come up with the compliance order.
Yes.
All right. It is MS so and so learned counsel. We record her name for respond to 1 and 2. It is expected that on the next date fix, the Alice contemner, the learned counsel with the Alice contemner shall appear with the compliance order of this court.
Contemner or correspondent?
Yes.
Advocate.
Alice contemner.
Advocate or?
No, on behalf of you'll have to appear and
Yes, please.
compliance. Yes.
Well, so for item 25 also, matter is always 2-day accommodation matter I require. Like, I some personal difficulty. I
You don't want to file affidavit or what?
Yes, madam.
Sure. And it's not required by our file, because it may not end here, it may go on the order.
So when do you want?
10, minus same day, madam. I'm coming.
Why you are saying 1 day accommodation? Let's take up tomorrow.
Because I'm coming from Gauhati, madam.
Next week.
Madam, this actually I have some other name.
Tuesday, next week, Tuesday.
Madam, 10, same day, madam. Same day, madam.
25. Huh?
WBC,
Okay.
WBC 127. WBC
On
127.
the prayer of Mr. S.K. Medil and counsel by the petitioner. And prayer not being objected to by learned counsel. For respondent, nah?
Yes, respondent number 2.
Respondent number 2. And Mr. Vijay for state respondents. List this matter on 10/10/2020.
My lord, affidavit of state is required in this case. Affidavit of state response is required.
If this on file is good for you,
Yes, yes. I love.
why could force them?
Yeah, I love.
Next, Lordship,
Yes,
what's my big mistake number 30?
30. Yes,
Lordship, my senior is on the medical treatment, so Lordship, we come up after 2 weeks, Lordship. 30.
Mr. Potico Pote. Learned counsel appear with Mr. P.B. Paul,
Lordship,
learned counsel by the petitioner. Come on, submitted. The leading counsel, Mr. P.B. Paul, the learned counsel is under medical treatment. Mr.
Respondents, madam.
Empty long learned counsel, respond number,
All the respondents.
all the respondents present. Prayer allowed list. List after
3 weeks, Lordship.
3 weeks,
Lordship, so I don't know 27.
27.
Lordship, here, our name is not reflected, but we are for years, number 5.
No, 2017 matter. Either you withdraw this.
No, I'm for the number 5.
Huh?
I'm for
Who's
the
got a respondent? I'm petitioner. Who's got a petitioner?
Yeah, no, Lordship, I'm for the 5.
Who's got petitioner?
Petitioners.
It's a judgment. 2001 judgment. Constitutional bench judgment. State of Maharashtra versus Milind. Have you seen it? Article 342, government cannot do anything. It's the president. You cannot add, delete. No. Is that the state government has no power?
Lordship, Lordship, since I'm the respondent 5.
Who is the
Yes,
petitioner?
right.
They may not be interested. 2017 matter.
Lordship, I've taken the one.
Petitioner.
Mr. S. Datta, senior advocate from Gauhati, Lordship.
Pakin Richo, local council is there, learned council is there. You just inform, we'll take up after some time.
Lordship, my senior is not here, Lordship.
Doesn't matter, we'll decide, we'll hear the petitioner and it's a settled matter. State has got nothing to do with the addition and deletion of the caste or tribe. No. 2001, 2000, way back in 2000, constitutional bench has already decided. No, constitutional bench of the Supreme. Huh?
What's in? And tomorrow, Lordship,
Who you are?
Lordship, I was
Respondent.
respondent 5.
Who is respondent 5?
Lordship, respondent 5 is the, he was included by an order that prior to 1963, permission of the state, I was settled here, and my parents were settled here. So my name was included as a indigenous. So my only prayer is that my indigenous and my status as indigenous of the state should not be indulged by this court. That's my only prayer.
You are respondent. How you can derive any right from the petitioner's case? Why you have been implemented? Why you are a party?
I filed an intervener, IE. I have the impression that the irony is on the court may quash my citizenship.
Are you aware? You must be aware what's happening around.
Lordship.
What's happening around the state?
Yes, Lordship. But Lordship, my name was included prior to the formation of the state of Nagaland.
These are very, it's neither the court nor the state government has any role to play.
No.
It is the Parliament of India by law, Article 342. And in the presidential order, nothing can be added or deleted or subtracted. It has to be by the Parliament. And 2017 matter, they may not be interested.
Lordship,
Find out. We'll take up to some time.
Lordship,
We'll take up.
tomorrow, Lordship.
No, we'll take up to some time. We'll see. We'll not dispose it of. You find out whether they are still interested or not. They might have come across, they might have realized that this matter has already been settled by the Supreme Court. So ask Mr. Who is that? Pakirincho to call his senior who is appearing here, Mr. S. Datta. Find out.
Lordship, in that way, the matter let it come tomorrow, Lordship.
Huh?
That would be more convenient because in this case, Alti Sankam is appearing in this matter, Lordship. So in that way,
If it is to be heard, we request the Advocate General to appear.
Come tomorrow, Lordship.
Lordship, if the matter can come up tomorrow, that would be more convenient for all the council, Lordship. So
Non appears for the petitioner.
No.
Mr. So and so appears for respondent number so and so, huh? This matter tomorrow,
Lordship.
19/9/2022. You read the judgment and come 2001 1 SCC page 4. The state of Maharashtra versus Milind.
Lordship, much better. Lordship, I also like mention 1929, Lordship. Yeah, I'm for the appellant. Lordship, if the matter come about 2 weeks, Lordship.
29.
29.
Okay. On the prayer of Mr. Posiko Pote, learned constable, after list this matter after
2 weeks.
4 weeks.
Lordship. Also quite good.
May I please lordship, I'd like to mention item number 13, madam. I thought that this matter may be listed after 2 weeks, madam.
13.
Yes, madam.
What is this?
This is a contempt petition for non-compliance of the court order. This is regarding the approval of completion ground.
MS Jimobi,
Lordship,
any objection? It appears to be a familiar case
yes,
for this court.
very much, Lordship.
What is this?
With regard to my lordship, past that in the writ petition, a genuine direction was given to the government for appointment on compassionate ground, lordship. Now they are supposed to rectify the seniority list.
It's under preparation, my lord. It will be published within a week or two. So it's at the final stage. So after the 2 weeks may be given so that
It will be complied with.
yes, the final list will be
Mr. Judge will be learned counsel for the MS Judge will learn counsel for the petition. Mr.
and no, my lord.
Learned counsel appearing on behalf of Alice Contemptor
Yes.
submits that he may be granted 2 weeks time so as to enable the authorities to comply the court's order. Just after 2 weeks, so as to enable Mr. So and so to produce the compliance order. All right. For 39,
Yes, Lordship.
section
Section 302, 120, please. 341 and 365, my lord. My lord, here,
what is the stage? Stage of, is it,
it's for consideration of charges, my lord.
huh?
However, consideration of charges, CC.
Okay, so in that case, which record we should call? Lower court, scan copy,
My lord, I've enclosed the charge sheet
huh?
in my petition.
Then in that
I've
case, we-
just received the copy this morning on this, so I may be given some time to go through the briefs, Your Lordship.
petition or the,
Petition, just
the
the
scan copy?
petition, petition.
We'll just say, we'll call for the scan copy of the lower court records. Is that it? Is it a lower court record?
Yes, your honor.
Huh?
Yes, Lordship.
Had Mr. So and so learned counsel for the petitioner. And also had MS,
S. Mary,
Ms. Mary for, learned PP for the state of Nagaland. Next para, this is an application under section 439 of CRPC 1973. Praying for release of the accused persons on bail in connection with their case number 34/2023 corresponding to Mokitsu PS case Roman 2 number 13 of 2023 under section 120B 341 362 302 IPC. Call for the scan copy of the lower court's record. List after 3 weeks.
Obliged, Lord.
Caveat teacher. Who is appearing for the caveat? Caveator? Caveat teachers, huh? You are for caveator?
Yes, Lordship.
Okay.
Some of the caveators.
Okay.
I'm also appearing for some of the caveators, but
Caveat, you just find out this caveat teachers, huh? Yes. Yes, madam.
Yes, my lord, lordship, item number 188 to 198 are analogous. 188 to 198 are
One,
analogous matters. It's
one.
just that the subject, respective subject.
Item 2 to item 12. Is it?
Yes, yes,
Yes.
with petition, I mean to say, with it.
Different subjects, assistant professor.
Assistant professors.
Okay, will you notice what's there?
Yes,
When they were appointed,
they were appointed, some before 6616, that was, enforcement of ban on appointment.
before 2016, the policy.
Before 666 as well as
After.
after 666. After placing before the Honorable Court on oath that no further contract appointment will be made. That is what the respondent in the previous case.
Is it a rule?
Is it a rule of
Is it a rule that no contract appointment shall be appointed?
lordship?
There's no absolute bar at the
There is no absolute bar, but without
exigencies of service, but it should not be
Yes,
allowed to
it should be-
continue.
through advertisement. Here,
It should not be allowed to continue for all time to come. That is the law. Is that it?
But-
Appointment as such on contract basis may not be illegal per se, but it may be irregular. But then in exigencies of service,
of course,
they
lordship,
have the authority.
of course, lordship.
But then it should not be allowed to continue for all time to come.
Yes, that is one aspect.
Yes,
That is one aspect. The second aspect is even be in administrative exigency for a short period of time or whatever, it should be through advertisement, general advertisement. So
yes.
here, in all the petitions, no advertisement, there was no advertisement, and their service has been extending till date. I have challenged your last extension order, that is.
No, first you show me the appointment order first. Where is the appointment order? One by one, because you were said some of them are after and some of them are before the 2016
Yes.
office memorandum.
My
Item 2, will you start from item 2?
yes,
Where's the appointment order?
35F and page 35F.
It's not 35F, page 35, annexer F.
F, lordship.
Yes,
Lordship. So the first petitioner is appointed to that is 11 to 11 F1 36 7 June 2016. This is after 6616. Then this is 14 July 2016, NSU F2. Then F3 is 24th August 2016. Then F4 is 7th August 2018. Then F5 is also 7th August 2018. Yes, these are the seven respondents, lordship. These are the 7 respondents. Respondent number 5, 6, and 10 are holding sanction post, lordship, substantive post.
what is this judgment of this court? Page 42.
Page 42 is. This is in the previous case, Lordship. This is the previous case where an NGO called Out Against Corruption and Unvetted Taxation filed writ petition before this honorable court. Then the single judge held that no further contract appointment or no regularization should be made.
Yes,
This one, the respondent government went for appeal in writ appeal 16K of 2018.
yes.
So the
Very good.
division bench
Ah,
dismissed the, shall I read out, my lord,
yes.
from paragraph 2? Or that is page 43.
No, no.
Page 50, paragraph 22. Shall I read out? Also?
Yes, ma'am.
Or from 21, paragraph 21, Lordship. The learned single judge in the impugned judgment and order dated 3/8/2018 passed in writ petition number 145K/2017 found that the action of the state government regularizing the service of the employees who have completed 3 years of continuous service on contract ad hoc basis in terms of those office memorandum dated 11/8/2016 and 4/8/2016 in violation of the law laid down by the Honorable Apex Court in the case of Uma Devi 3, Supra. 22. As such, the impugned decision of the learned single judge 3/8/2018 disposing of the said writ petition number 145K/2017 being not maintainable in the form it was filed without dismissing the same on merit and granting liberty to the petitioners of the said writ petition to make fresh challenge to the appointments of the impleaded respondents therein and other persons as per law. We are of the view that the learned single judge did not commit any illegality in directing the state respondents, the appellants herein, not to regularize any person who has completed only 3 years of continuous service on contract ad hoc basis in terms of those office memorandums dated 4/8/2016 and 11/8/2016 noted above. As those OM are found to be not in conformity with the law laid down by the Honorable Apex Court in the case of Uma Devi 3 Supra. 23. Accordingly, we are of the opinion that the direction and observation made in the impugned judgment.
So, by virtue of this, we are challenging their appointments.
This also, but this is in continuation, Lordship, this.
See, first, single judge dismiss the writ petition on maintainability, but then there is a direction
Yes, Lordship.
you may challenge the appointments. In the meantime, there was a finding that these memorandums is not in conformity with the judgment of the Uma Devi.
Lordship.
Therefore, no regularization.
Lordship.
So this what then what remains?
That is one aspect. The second aspect is after this was the account, that is an NGO, Lordship. They collected all the data, but they did not collect the it has a long background, Lordship. The rampant backdoor appointment that the state is facing today. What has happened is our court collected all the data of all the department. It was 706 gazetted posts were challenged, but they did not. For 2 years they collected the data of all the department, but unfortunately they did not collect the appointment orders. So with that data, our court approached this honorable court. However, the honorable court said that since there is no challenge to an individual employee, that was the maintainability, Lordship. So the case, although it was dismissed, the petitioners were given liberty to approach this honorable court.
At the same time, the court held that you cannot regularize those ad hoc employees who have
Yes.
completed 3 years.
Yes,
So nothing survived. What is there?
that is
It's
what-
just technical that you have not challenged the those contract.
yes, Lordship.
The persons
Yes,
who have been appointed on contract basis. That's only technical thing. But
Yes.
the issue, the larger issue or the question about the regularization, that has been already
Already,
done by-
yes.
So there's
Yes.
nothing,
Lordship.
you will just issue
Just
notice,
just a
you will
little,
just issue notice.
just a
nothing is
little, background, Lordship.
Hmm.
After this, net qualified, they form a forum, Nagaland Net Qualified Forum. They approached this honorable court in writ petition 112 and 65, two writ petitions were filed. It took 3 years. Also it took 5 days of hearing,
12 of 2020,
19, 12 of 2019. I have, in my paragraph 8, I have mentioned that.
and this is 2016.
Paragraph,
What about those cases? 2000 WA12 is all similar.
This is the fourth round of litigation. In the first round of litigation, an association account, that is with regard to the against corruption, taxation and all this. They have filed a writ petition challenging the appointment of the petitioners, the respondents. That writ petition was dismissed on maintainability. Thereafter, the second writ petition was filed under the name and style of Need Qualified Forum. That writ petition was also dismissed. And an observation was made by the learned single judge that the state respondents shall not regularize those persons who have completed only 3 years and a token contract in terms of the two office memorandum, that is 2008 and 2016 office memorandums. That observation was referred by the division bench, which my learned friend has referred to in paragraph 21 of the division bench judgment. The division bench had not given a clear finding nor clear opinion, but the statement which is made in paragraph 21 is only a reiteration of what the learned single judge has held, where the writ petition was dismissed. And ultimately, the honorable division bench has upheld the order passed by the learned single judge.
that is the
Therefore,
previous one.
the present position is that the finding given by the learned single judge is in existence,
Yes.
revealing where state cannot regularize those who have completed only 3 years. It doesn't say about the more than 3 years. And the two office memorandums have not been quashed or interfered by either by the single judge and by the division bench. But ultimately, the Need Qualified Forum case has also been dismissed on the ground of maintainability. And this is the third round of litigation they are approaching this honorable court. And with a prayer that our services should be terminated.
Of course,
The appointments were made sometime in 2010 to 2016. Only one in 2016, rest are prior to that.
delayed.
Now they are coming and saying, and those are the persons, lordship, who are working on fixed pay of 20,000 per month. We are well qualified. Some are PhD holders, and we have passed MA, mid qualified, and getting a maker salary of rupees 20,000 per month.
Lordship,
Now, the one advertisement,
why not?
welcome. Let it be advertised.
Yes,
Last time also in 2019, it was advertised. Petitioners, only 4 petitioners passed in the NPC exam. However, there were 9 persons among the respondents who qualified in the NPC exam.
of course.
And for filling up the post, whether it should be advertised or not be advertised, non-sanctioned post, whether a direction can be issued by this honorable court to advertise the post.
Why?
Whenever we sanction post, it is not only the payment of salary. Once a person is appointed to a service, definitely all service facilities will come. And it is up to the state government, which post should be filled up and which post should not be filled up. Now, petitioner in one court, both sanctioned and non-sanctioned posts should be advertised. Welcome. Let it be advertised also.
Then the case is finished.
So that we will also have an opportunity to complete the post. And we are working at present with a maker salary of 20,000 per month.
It's okay, sir. But
So
it's not, we cannot, court cannot direct to fill up the post. But since
That
you
is
have
what I
decided,
submitted.
if you have decided to fill up the post, allowing somebody to work on contract basis, yeah, the form is to be filled up. In that case, you have to advertise.
Yes, that is what we are asking. We are coming before.
Some of the respondents are.
We cannot force you to fill, of course, the government to fill up the post. If you want to fill up it, you have to advertise.
At this stage, lordship notice may be issued and I'll accept notice for few respondents.
So we'll just hear the government. Okay, it's okay. At best, we can issue notice today, we'll see. But then why? Are you want to fill up the post? It indicates so, because you have allowed these people to, I mean, the respondent to continue.
Yes, they are continuing the.
For last 10 years, 5 years, 6 years. Why?
When you're,
That means the post has to be filled up. You want to fill up the post. On next day, this can be disposed of.
Let notice go.
But it's
Because whatever sanction
we cannot
was-
force them to
Yes.
fill up. But if they want to fill up, it has to be in accordance with constitutional provision of
That's right,
public
that's right.
employment, that's all.
sanction post, it has to be filled up within 1 year.
Sanction board, not sanction board will not go into that, but the decision is up to the government to fill up it, not to fill up. If they want to fill up, you have to go by the scheme of public employment. If they don't want, we cannot force them to fill up. Correct?
Lordship, here the question is, I am the.
Lordship,
Allow me to.
For opening the colleges,
Yes.
people are demanding that the teachers should be in the classrooms. Without the teachers, how the class will function?
Okay.
But I think we continue.
We'll come there.
That is the-
Today,
You'll be given a chance. Today we'll hear the petitioner.
Lordship, here the
Yes.
question is, this rampant backdoor appointment.
I understood. I have understood.
Yes.
So you issue notice.
I
Because-
also have in the previous petition, we have filed one big petition and their interim has been granted that no regularization should be given to the.
No, that one, see, the Leonard Single Judge, coordinate bench already passed it, that has been affirmed by the
Lordship,
division bench.
Lordship,
So, we cannot pass order over the order. If they are regularizing, you come per contempt. All right? Because this will amount to passing an order over the order.
that
Because
will
the
be-
single
that
bench,
will be reflected, Lordship.
wrongly, rightly, single bench has, coordinates bench of this court has said, no regularization.
Lordship,
Whatever they interpret,
the problem
that-
here is, despite of those,
then you can,
regularization has been made.
no, in that,
Lordship, kindly,
no, in that case, you have to file a contempt. Had there been no order by this coordinate bench and upheld by the
Lordship,
appellate court,
Lordship.
we will not pass any order on that. If there is a violation of that, whatever may be, whatever interpretation they take, that will be in the different proceedings. All right. Mr. Miss.
Just,
Judge,
if
you
you
will-
want to refer to the previous,
What?
same petition.
Ah. So we will not refer all this thing. We'll issue notice today.
Interim has been-
Already the interim is all in your favor in some other, I mean, proceedings. Why you should pass?
This is the previous, another petition,
It's
those
okay.
unqualified.
Yes. But better is less to say no regularization.
Yes, only that, only
Then
that,
in that case,
only that much.
if there is,
only that.
if there is any violation or no compliance, whatever.
No regularization, yes,
we
only
will
that
take
much.
appropriate procedure.
Lordship.
MS. Judge Jimmy learned counsel for the petitioner. Also heard B. Shokri, MS B. Shokri, learned counsel. learned additional advocate general for respondent number 1 to 4.
You know, the-
I may be allowed to submit the list of respondents there or not.
You just.
I have prepared the chart where I'm not sure
Okay.
appearing for the.
Okay.
what are the first mentions?
You find out all this.
Against
So,
whom I'm appealing,
uh,
those are mentioned
Mr.
there.
City Javid,
In the
learned
chart.
senior counsel assisted by so and so, and
Illegal.
Eliralu for respondent number so and so. You find out or whoever it is. Challenges made in this writ petition is the appointment of the private respondents 5 to 11. Namely so and so, so and so.
Yeah.
As assistant professor,
I'm appearing for others.
this is item 2 is for assistant professor for commerce, huh?
For commerce law chief. 188
In
is.
item 2, I'm not appearing. From item 3 to,
You just give the mark there, huh?
yes, I have mentioned all the.
We'll take one by one, huh? Assistant professor commerce, within bracket commerce, huh? On contract basis. On the ground that the respondents
That is what I'm concerned.
have been appointed through backdoor. And have been allowed to continue by extending their services from time to time without recourse to the selection process as required under the law. Issue notice returnable within 4 weeks. Since the learned counsel to the respondents have already entered appearance, no formal notice needs to be served. However, extra copies be served to the learned counsel for the respondents within 2 days. Requisite extra copies. List after 4 weeks.
So, in the meantime, no regularization.
No, since you have already in your favor in other proceedings, it is not required. That's what I'm saying. Order after order, over the order we cannot pass. That will be unnecessary.
I don't know. Oh, that's question.
Item number 3, caveat, discharge the caveat. The subject will be different, huh? Assistant professor, English, will be all till up to item 12, huh? You find out from the all subject, huh? After 12, no?
Yes, no.
Yes. What is this? Is there any urgency in this matter?
He's due to retire also in December.
We'll admit this in list for hearing. All the
He's
matters.
retiring, that's a problem.
It's okay. Doesn't matter. You'll get, are you praying for any service benefits?
So actually, now I'm in service.
Ah.
I am in service now.
So,
I am in service. I am due to retire in 31st of December, because criminal cases, they are not processing my pension.
before that we'll decide. We'll admit this. That's why I'm saying, why urgency is there? Any urgency?
Urgency is there because of this, because everything is hanging on his head, so the problem is there.
The reason is of 2022.
Yes, sir,
We're dealing with the matter of 2017, which has been part hard also.
I fully agree. I
Well,
was
Mr.
questioning the
So
question.
we'll give the first preference. So
Yeah.
due to it is in the admission stage, We'll admit the petition and listen for hearing.
Full story, that's the
Huh?
problem. It will go to the full story. That's the whole problem, your
No,
lord.
no, it's not go. It's not go.
Well, otherwise, problem.
Because admission stage, it's
Because
not,
they,
it's all.
because of these cases, they are not processing they are not accepting pension papers, your lordship.
Or else I'll hear you and we'll admit the petition. Instead of wasting the time, that's why I'm saying, we'll admit this and we'll fix for hearing.
Lordship is fixing a date, your lordship.
We'll admit it and fix for hearing, is it? Somewhere first week of October, whatever you like.
You fix another date because.
Because I have taken up this matter for quite a number of times. So it's listed, or whenever it is listed, it's not appropriate to hear the matter because this will take all day.
You take it.
Otherwise that 2017 matter will be again.
Yeah, I feel you. I feel you. Yeah, lordship, I
So
fully
that's what I'm saying.
I
whether
fully
they-
get lordship difficulties.
Ah.
Because the only thing is in the meantime, they should process my pension paper. That they are not.
No.
No, you.
They are not accepting. They are not accepting.
Yes, no, absorb from the case, your lordship.
You are still working. You are still serving, no?
Yes, yes.
Are you on suspension?
No.
You are
Suspend and quest.
Oh, you are serving.
Suspend and quest.
Then there is no urgency. I have Mr. Prabhu Chakraborty, Chaudhary, sorry, Prabhu Chaudhary, learned counsel for the petitioner, and also have MS. Bisokri, you are PP,
Yes, no.
learned PP for the state of Nagaland. Admit. Next part, list poll hearing. On, you just choose the date.
October.
We have October, November, 3 months we have.
I was it fast there, which is convenient because instead of it that's. Because I.
You just choose the date and give it to her. Huh? Next. What is this? Sir,
Worship here. Is a petition for review under order 47-1, raised with the chapter 10 of the Gauhati civil rules.
what is to be reviewed?
Your worship here, as per the prayer, the petitioner, they said that the whatever benefit it earned during the war charge was not included in the ROB 1993. But your worship here, we received, this matter was passed by a command judgment order dated 24/9/2019. So it covers WBC 201 of 2017 and WBC 202 of 2017 and WBC 237 of 2018. So it was
This is what.
passed by the command judgment and order dated 24/9/2019.
This 65 is for what? Condonation of delay,
Yes,
huh?
yes, condemnation. Yes, worship.
How many days?
920 days. 920 days.
Huh? 960 days.
Yes. Your worship here by
Do you have
the.
any objection?
Your lordship, no, I don't have any objection.
So we'll
Yes,
condone the delay.
Yes, Lord.
But what is to be reviewed?
Regarding the ROB, the claim made by the petitioners, it was already covered in the ROB 1993.
Yes.
But at the time of hearing of the original petition, the respondent state could not brought to the notice of the court.
It's a discovery or discovery of new facts.
Yes, yes. It was
Or
already
discovery
done.
of the documents.
Your worship, it was already done, but it could not be brought to the notice of the original petition. So for which
This is passed by whom?
single bench,
Who? Has he retired?
justice Setu.
Oh. In that case, this court can take up.
Yes, Lord.
Okay. So we'll condemn the delay and we'll see.
Yes,
Any objection to the review?
objection, your lordship, yes, lordship.
Huh?
Yes, lordship. But let the IEB dispose of your
Okay.
lordship, so that we can fix it.
Aye, huh? Had Mr. M.T. himself, landed additional advocate general, appearing on behalf of the applicant state by filing this application next page. Also heard Mr. Subramati, landed counsel, appearing for respondents 1, 2,
Sole respondent, your lordship.
huh?
Sole respondents.
Not sole respondent. There are, huh? 102 something. Huh?
Yes, lordship.
All the respondents.
Yes, lordship.
There are around 100.
Yes, lordship. I was the petitioner, your lordship, in the petition also, lordship.
So why you are saying sole respondent?
That means,
There are
respondent.
100 respondents
Yes, lord.
for all the respondents, huh? By filing this application under section 5 of Limitation Act 1962, the applicant pressed for condonation of 960 days in filing the connected review petition. Yes, next page. Having considered the explanation given by the applicant, coupled with the submission of the learned counsel for the respondents of not having any objection to objection for condoning the delay of 960 days. Come on. This court is satisfied that the sufficient cause has been shown, is prevented the applicant from filing the connected review petition within time. Accordingly, the delay of 960 days in filing the connected review petition is condemned. The IA extends disclosure accordingly. In review petition, in view of the order passed in so and so in IA, list this matter after 4 weeks.
Yes, lordship.
All the, it's up to, it says same. Item 18 to 22, same.
Yes, lordship.
Same. Three, all the 3 years. What is this, sir?
This was of an FIR and a notice that has other section 41A is issued subsequently.
Section?
The sections are not there, but that is the peculiarity of the case, but no FIR has been registered.
So how to go with it then?
Yes.
How to go with it?
Lordship, FIR has been registered.
Registered. Then call for the city, we'll call for the city.
City was called for.
City is there. City is there.
No, Lordship, I'm allowed to call for the city, Lordship, on the next.
So last time city was called.
That was, but since now the FIR has been registered, Lordship, I'm allowed to take the latest city, Lordship. I'm allowed to produce the latest city.
Well, order dated 1/6/2023. Perusal of the case diary is also felt necessary, and scan copy of the case diary may be produced by the learned public prosecutor on the next day. Order dated 1/6/2023.
Where it is? You're reading
The
where?
last paragraph.
Huh?
First page, page number 2 in the last paragraph. Order dated 1/6/2023.
1/6. Ah,
Last paragraph of page number 2 of the order.
as regards, sorry, learned counsel submitted. This one.
Last paragraph, perusal of the case diary is also felt necessary. The notice is returnable on 30th June 2023. Perusal of the case diary is also necessary, and scan copy of the case diary may be produced by the learned public prosecutor.
Ah.
Have you ever seen
You don't have.
Lordship, I have, but that is not the latest, Lordship, so I'm allowed to produce the latest.
Because you said it has not been registered.
Yes, as of now,
You
you
said
said
it's been registered.
Yes, Lordship.
We'll call for the case diary.
Because submit what the matter otherwise would require hearing.
Ah.
Just come for admission. It was actually admits the matter because private party is also there. Matter he may also file the affidavit. And matter can be disposed of at one stage.
What do you say?
I'm not filing an appeal.
You are not filing it.
So that
Then we'll admit and fix it for hearing. Okay.
that he's not filing affidavit that may also be recorded.
Mr. P.J. Shekhar, senior counsel, assisted by MS. So it's a learned counsel for the petitioner. Also heard B.G. Momi, learned PP for the state, and Mr. Lima Wapa, learned counsel for the learned counsel appears for respondent number 2. Okay. Admit this petition. List for hearing on. In the, you just take that. In the meantime, the learned PP shall produce the scanned copy of the case diary.
The minimum is
17th of October.
Now that respondent number 2 is not filing the affidavit.
Before that, huh? Before admit, huh? Mr. Lima Walker, learned counsel for the respondent. Submits that he would not like to file affidavit in opposition. Otherwise, it's not also required also. We'll go by the records.
Because
Records of the tenor and records of the matter.
documents are there. This is basically a civil dispute. It's documents which are signed by the.
We'll allow.
The interim order passed earlier.
Earlier, then admit list for hearing. Then that learned PP shall produce the case, scan copy of case there. And interim order passed earlier shall continue. List for hearing on which day? 17th. Yes. That two on top. That the list for hearing on so and so.
Item number 4.
Yes. Any improvement in your case?
Your Lordship.
Yes.
I have to mention the apex court judgment on 20 to Fansil versus the state of Kerala 2021 for SSC 1.
What does it say?
Lordship, in para 158.1, it says that the offense, I'm able to. That the officer who are invested with power under section.
It says, if the statement on section 67, in that case, you cannot rely on it. It says that the statement under section 67 cannot be relied.
Yes. Yes.
To Pansing.
Yes. And
The statements are recorded under 161 of the CRPC, Your Lordship. So it's relevant. Yes, Your Lordship. 161.
Not 67.
Note 67.
Why not 67?
Your Lordship, they are not familiar with that section, so all the statements are recorded under 161.
So according to 161 is
Relevant
As-
for
as good
consideration of bail, Your Lordship.
as good as that of 67.
Lordship.
No statement under 167, so we cannot rely on that to Pansing. To Pansing.
Yes, Lordship.
Paragraph?
Paragraph 150, 158, 158.
158. Paragraph.
Yes.
Huh? 16, there's no statement recorded under 67. You are saying that the statement recorded under section 6 NDPS cannot be
Yes, Lordship.
use a constitutional statement in the trial. There's no statement under section 67.
In 161 of the CRPC.
Charge sheet has been filed.
Charge sheet. A sample has been sent for forensic science laboratory.
How many
And
days now? How many days now?
It's more than 2 months.
Roughly 2 months, Your Lordship.
2 months means what?
Yes.
60 days.
60 days.
What is the author limit under NDPS?
That I'll have to check. 180, I guess.
180.
But Lord,
So section 37, there are only two grounds you can be, I mean, that has been complied with by the court while granting or considering the bail under NDPS. One is that public prosecutor has to be heard, that she is there. Number two is the court must have a reasonable belief that prima facie the accused is not guilty. But in this case, prima facie rather, there's no, I mean, nothing to show that the accused is prima facie not guilty.
Lordship,
So bail cannot be granted. That is the problem.
but your
I
Lordship,
understand you are a lady. But under the NDPS, it's a mandatory. Court has to have a finding that prima facie the accused is not guilty, which you find contra in this case. So what to do?
may I please your Lordship.
Tupan Singh, forget it. That is settled position. It's not relevant.
But your Lordship,
Huh?
in even 161 is not admissible as per the
No, it's not admissible. Admissible. That's what I'm saying.
Your Lordship,
Forget 161. Why not relying 161? For the purpose of convicting or something. We just, for the purpose of the bail, this court has to have a finding that the accused is prima facie not guilty. Then only bail can be granted. If not, bail will be rejected.
but your Lordship, in this case,
Yes.
the alleged accused was not in possession of the contraband. She was just merely a victim of circumstances. Nothing has been, I look from her also, your Lordship. She was not aware, Lordship. She was not aware that the contraband was there at her residence, Lordship. And moreover, your Lordship,
According to you, the statement under 161 should not be relied on
Yes.
while considering the bail. We are not relying on the materials, whatever statement, it's not relying as such, but we have to find out somewhere something from the record.
Your lordship,
You have said so. You know that sunflower and all those, it is sunflower.
Yes, yes, yes.
Lordship,
Heroin,
that's-
your lordship.
You have been associated and you know that.
Yes, your lordship.
And
And the
it is-
accused
it
husband
is-
is the man,
it is-
one of the men.
It is hard to believe that you are a wife, doesn't know that things are placed at your residence.
but your lordship being a wife, that doesn't mean that I have to be a part of every activity that's on my.
You must.
Your lordship.
Husband must also know the activities of his wife, and wife equally has the authority and right to know the activities of her husband.
But I may be allowed to, your lordship, if it's not supposed to be your lordship
Huh?
regarding, your lordship regarding 161 of this statement.
No, 161, forget it. We are not relying as such.
Your lordship, if we rely on that, then it will infringe my individual rights because it will be against my.
You show that prima facie you are not guilty. And substantiate it. Just saying will not do. You substantiated that prima facie, why this court may not be persuaded to say that prima facie you are not guilty.
Your lordship, but still lordship, I was not aware. Your lordship, I was not aware of the counterpart. And even in my husband,
When it was recovered, you were there. It was recovered from your house only.
Yes,
But it was lordship, not the house, but it was recovered from a storeroom near the house, your lordship. And then she was not aware about it.
no.
And since your lordship,
Just keep it. NDPS Act. We'll dispose it of. Make your submission,
so in that case, your lordship, I would like to.
one by one. First is
161.
161.
Lordship.
No, don't come to, how do you know that what the statement is given in the 161? Have you privy to the case diary? Then how you start from 161? 161, after her submission only you can say.
Prosecution counsel is insisting on that. Your lordship, in the case that I would like to go to the Indian Evidence Act of 19.
Limitation Act,
No, Evidence Act.
okay. No, at this stage, will not. But then for your satisfaction, we'll just, evidence, which section?
25
Yes,
and 26, your lordship.
yes.
I may be allowed to read.
Confession to the police officer not to be proved.
To a police officer, not to be proved. No your lordship. I may be allowed to read. No confession meant to a police officer shall be proved as against a person accused of an offense, your lordship. 25 to 26, confession by accused while in custody of police is not to be proved against him. No confession made by any person while is in the custody of the police officer, unless it is met in the immediate presence of a magistrate, shall be proved as against such person, your lordship. So your lordship, from here.
I'm not proving or disproving this in this proceedings.
But your lordship, the statement in front of the IO will not be admissible because your lordship, it will just infringe my.
We're not admitting or not dismissing it, the statement. We just only have a look at the statement. That will be before the court only, trial court, to prove, not to prove. At this stage of bail, it's very difficult. Forget about 25 and 26. Anything else?
In that case, your lordship. Not
Ah.
much to say, since
So according to you, the statement under 161 of the CRPC should not be, is not admissible, therefore it should not be
yes. used against the alleged accused. Used against the alleged.
It should not be taken against the alleged accused because it's not admissible. It was made
Even if-
before the police.
Your Lordship,
Obviously, 161 is before the police only.
yes. But your lordship,
Okay, next
I may be allowed to present the.
judgment. I think it's not, it is for bail.
Yes.
Is it for bail?
Yes.
Okay. Yes, Bharat Chaudhary. Paragraph.
Paragraph 10.
After careful.
Your lordship, here the alleged accused was also accused because nothing was apprehended from his hand, your lordship. He was not in possession of any of the contraband. It was only because of the statement made by the another alleged accused that he was arrested, your lordship. And here also, lordship, in this case also, Tufan Singh versus the state of Kerala has been mentioned, your lordship. Your lordship, nothing has been found
You read
in
it,
his possession.
paragraph 10, you read it so that she can reply.
Paragraph that after carefully examining the arguments advanced by learned counsel for the parties and having curiously glanced at the report, we are of the opinion that the impugned order can still be well granted in favor of Bharat Chaudhary. Accused A4 is not sustainable in view of the fact that.
PP, are you?
It's regarding NDPS.
I have read it. She is reading for you.
Not
By this, what was their tablets were seized, and it was sent for examination. And because of non-availability of the facilities, it could not be. So it was not this. In view of that, prosecution cannot rely until that it is confirmed that the tablets or whatever is a contraband items. So on that, you just cannot, say that, conclude that he is guilty.
But here, prima facie, your lordship.
No, just wait, we'll come back. We'll come back to that. That is the on that you have to reply.
Your lordship, here, even in this case, the alleged accused was not in concert positions of the contraband, your lordship, and she was not, your lordship. He was not aware that it was in her, your lordship.
Yes. Nothing was seized, nothing was found from you. It was only from your husband, though it was from your house.
Your lordship, even
You have
in the-
nothing to do.
Yes, even in the.
You
Caesar
don't know
memo,
anything.
My name is not mentioned, your lordship.
Huh?
Even in the Caesar memo, my name is not mentioned, your lordship. Your lordship, that is in my petition. In page 17, annexure D.
Page,
17, annexure D. Only the husband name is reflected in lordship.
if in the seizure memo, if your name is not mentioned, is it a ground for granting your bail?
Your lordship, but still, your lordship, I was not aware of the contraband that was found in my place, Your Lord.
It's okay. Then next. That's all. Madam? Yes, PP. Her submission is that nothing was seized from her. It was from her husband only. Just because she is their wife, though she doesn't have anything to do it and she doesn't have any knowledge. She's just the victim of circumstances. Just because she's a wife, that's why she has been wrapped into. Now, then she said, the contraband seized has not been proved as yet. So you cannot say that this is a contraband items. Number 3, she said, on the basis of your submission, the statement under section 161 cannot be relied on because it was made before the police. It is not admissible. Therefore, this court should held that prima facie she is not prima facie, she is not. This court should have a reasonable belief that prima facie she is not guilty. Therefore, bail should be granted. More so, she is a lady having 2 kids, small kids.
Your lordship, here, the statement says otherwise, so if I may be allowed to place.
No,
the
statement said, she said you cannot rely on the statement under 161.
No, this is relevant, your lordship. 161 is relevant for.
Why is it
consideration of bail.
relevant? Just
Your lordship, this is the only material we could rely on for the consideration of bail.
no, if it is only the only the materials which you can held that she is also involved. So it may not be. Because 161 made before the police.
Yes, your lordship.
So it's neither, it's not even a confession.
Your lordship, the fact that the commercial quantity is seized from their position, your lordship.
Not
that-
their position in the sense, she's saying not from me, it's from her husband.
No, it is her statement, your lordship.
That's why her statement, she said this is under 161 before the police,
Lordship.
under question. She was forced to make a statement.
No, your lordship. That is not your lordship.
So you just show me 160 on the basis of 161, can we rely?
Your lordship, in that case, I may be given a time to your lordship.
Your lordship, I just in short submission, your lordship.
Use the mic.
Otherwise, your lordship, I'll be relying on that Supreme Court judgment regarding the.
No, it depends on case to case.
Your lordship, in Article 20, in subsection 3, it says that no person accused of any offense shall be compelled to be a witness to himself, your lordship. Even that article is Article 20, subsection 3, your lordship. No person accused of any offense shall be compelled to be a witness to himself, your lordship. So
That is-
161 is your lordship.
Madam, that is totally in a different context.
But still, your lordship.
You read the commentary on that. She may help you, it may help you in some other case. So according to you, the 161 statement can be relied on
Yes,
and that should not be granted.
yes, your lordship.
Why? On what basis?
Your lordship, because,
You don't have
because,
161 statement.
yes, your lordship,
It is-
because the reverse of
it is
section
before- this is
37.
Before the police only, recorded by the
Before the
police,
police, but these are the preliminary investigation done by the police.
then thereafter anything else?
We are, the status is we are waiting for
Let
the
us,
FSL report, your lordship.
then in that case, this, the cases he relied, Bharat Chaudhary. It has not yet been, it has not been shown that it is a deceased item is a contraband item. It is just a presumption.
That is till the report is.
So in that case, Bharat Chaudhary is correct. In that case, it was sent and the FSL report says that in view of the non-availability of that system, it could not be determined.
But in our
Yes.
case, we are waiting for the report, your
Ah.
lordship.
So in that
So-
case, they said, but we are waiting for until the time. Can you suppose tomorrow, if it's answer to be negative, will compensate as a personal liberty. Also, you have not seized anything from her
From their house, your lordship.
house, not from her.
No, from their possession, your lordship.
Not-
It is their house. That's
No,
why your lordship, if
not
your
from
lordship
her
can see the
possession, that's
the
right.
statement of the petitioner's husband also supports. your
161.
lordship. Yes,
161.
yes, your lordship.
Okay, so you rely on the 161.
Yes, your lordship.
Heard MS so and so, learned counsel for the petitioner. And also heard MS so and so, London public prosecutor for the state. By filing this application under section 439 of the Criminal Procedure Code 1973. Read with section 37 of NDPS Act 1985. The applicant prays for release of the accused. What is the name of the accused? Srimati Kidu Lana. Ah? Kidu Lana. In connection with GR case number 339 of 2022, corresponding to West PS case number 4420-23 under section 34 of IPC, read with section 22 within bracket C, small c, bracket close of NDPS Act 1985. Next paragraph. The case set up by the prosecution is that a sumoto FIR dated 25/23 of West PS case number 044/2023 was registered on 22/6/2023. Next paragraph. The At around 4:30 hours, the AIT team. What is AIT? Huh?
Anti-extortion.
Huh?
Anti-extortion.
Anti-extortion team within bracket AIT, led by SCP West, OC West PS, and personnel of West PS Dimapur conducted a raid at Padampukri near Om Church and apprehended the accused from her husband and other two friends, along with two vehicles, one Baleno bin registration number LN07CA5143, two Genon pickup registration number AS06BC0060, five mobile phone, mobile phones, for 59 packet of suspected heroin within bracket sunflower of approximately 748 grams. Where the seizure list? Seizure memo?
Next should be.
Page 17. Huh. It's page 17, huh? Page 17. Serial number 10, huh? Thereafter, year 339 of 2023 was filed in connection with the aforesaid PS case number 044 of 2023 under section 22 within bracket C bracket clause of NDPS Act 1985. You were arrested on the same day,
Yes.
along with your husband and other two friends.
That is the second.
Since then, since her arrest on 2/6/2023, the accused Srimati so-and-so is in jail. The accused approached the, where is that bail rejection?
That's in annexure E, page 18.
The accused, next para, the accused approached the court of district and principal district and session judge for bail, Herbert, by the order dated 27/2023. the bail of the petitioner. The bail of the accused was rejected. On the ground that the quantity seized from the accused persons are of commercial quantity and that the rigors of section 37 would come into play. As the is 748 grams of heroin were recovered from the husband and wife. Therefore, it cannot be said that the accused persons are not guilty for offense at charge against them. These are by your this is your bail application or it was common bail application? Your application separately.
Yes, sir.
Okay. Next paragraph. I'm a so and so learner country for the petition semester. She is a mother of two minor school going children, aged about 6 years and 8 years respectively. And since the accused has been arrested on 2/6/2023, her minor two children are living in a traumatic state. And it has affected their daily life as they are not able to receive the love and care from the accused. And often the children as an individual faced difficulties and even social stigma. The learned concept to the petitioner semester. Nothing was seized from her possession, though it is claimed that the concerns in seizure, the alleged item of 748 grams was seized from the possession of your husband. From their house, huh?
In a storeroom.
Huh?
In a storeroom, Your Lordship,
From their house
which was not attached to
that
the.
is within bracket store, which is attached to the
No,
house.
Your Lordship, the storeroom was not attached to the house.
which is separately
Different premises.
standing next to the house, separately standing next to the house. Next one. And therefore, she has no knowledge of the said contraband items as alleged to have been seized from the store. Next one. And it's so that for the semester on the submission that the accused has made a statement under 161 of CRPC. What it says, What's he said? 161.
Just a moment, Your Lordship. Section 161 of the.
No. What's he said in the 161 statement?
161
In
statement, Your
CD.
Lordship. Yes, Your Lordship. The whole of the statement.
No, whatever she said.
Just relevant. I offer
Well-
meals and while taking rest, the police personnel raided our house and recovered 59 packets of suspected heroin, sunflower of approximately 748 grams, which was kept by my husband and later we were brought to police station. And just a relevant portion, Your Lordship, from the.
Just wait, that. The statement recorded so and so under 161, huh? That. The police has seized the contraband item of so and so, huh?
Yes. And
You
also,
just,
Your
you
Lordship,
just
here,
give me that
yes, yes.
from the house. Which was kept by her husband. Mr. Then next, what she said?
I have accompanied my husband twice or thrice when my husband delivered sunflower to Romijan. This is one of the men accused, Your Lordship, Romijan. Statement starts from page 20, Your Lordship.
And the statement that I had she accompanied her husband twice or thrice. When her husband delivered sunflower to Romijan, within bracket, men accused, cannot be relied on, as the statements alleged to have been made have been recorded. Well, they have recorded before the police. Well, the accused is in police custody. She refers to the section 25 and 26 of the Evidence Act. Give me that act here, Evidence Act. Evidence Act, so as to bring home to our submission that the statement recorded under 161 cannot be accepted and relied upon. Next slide. She has placed reliance on the judgment of the Honorable Supreme Court in the case of Sahimina Biswas versus State of West Bengal. In SLP within bracket CRL number 121/16 of 2022, decided on 01/03/2023. You have relied to judgment only. This one also. And Bharat Chaudhary versus Union of India, reported in 2021 SCC online SC 1235. Next paragraph. I am assured so learned public proceeding. While referring to the case ready, submits that the accused has clearly admitted her involvement in the matter, wherein she has stated that the contraband so and so grams have been recovered by the police from our house, and she had accompanied her husband twice or thrice while delivering the contraband to one, what was his name?
Romijan,
Romijan,
the main accused.
the main accused in the matter. Therefore, the NDPS, the matter being, and then since the matter is since therefore, since he has admitted her involvement, there is no reason, there is no reasonable ground to satisfy of the court that she is not guilty of such offense, which is a prerequisite condition and mandatory requirements under Section 37 of NDPS Act. She has relied on the judgment of Honorable Supreme Court in the case of Union of India versus Ajay Kumar Singh, reported in 2023 SCC online, SC 346. I have considered, heard and considered the submission of learned counsel for the parties, and also there is the case diary. Next paragraph. It is number, it is Section 37 of the NDPS Act introduced provides that no person accused of an offense involving commercial quantity shall be released on bail unless the twin conditions laid down herein are satisfied. Namely, the public prosecutor has been given an opportunity to oppose the bail application, And the court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offense. And that he is not likely to commit any such offense while on bail. The next paragraph. No, next paragraph, continues. It is opposite to refer to the section 37(1), which is reproduced here in the section 37. You quote the section 37, huh? In the case of Susmita Biswas, the Honorable Supreme Court has observed observe as follows. Then next is in Bharat Chaudhary versus Union of India versus so and so. Para 10. Then next para, Union of India, in the case of Union of India versus Ajay Kumar Singh. Supra, both judges Supra. Three cases will be Supra. It is Bharat Kumar is para 10, you quote the para 10. And yours, this is your method, Ajay Kumar is para?
Ajay Kumar Singh, your lordship.
Para?
There are 14 to, yeah.
14,
19.
15,
Yeah,
16.
yeah. Yeah.
On careful consideration of the case that is and the observation made by the Honorable Supreme Court. And the provisions of section 37(1) of NDPS Act. It is clear that no person accused of an offense involving trade in commercial quantity of narcotics is liable to be released on bail unless the court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offense and that he is not likely to commit any offense while on bail. Next paragraph. It is not disputed that 748 grams of alleged contraband items have been seized from the house of the accused. Which is more than commercial quantity.
Commercial quantity, small quantity is 5, commercial is 250 and above.
So more than commercial quantity.
Yes.
Understand. It is also seen from the record that the accused has stated that she had accompanied his husband twice or thrice while delivering the contraband item to the main accused. In view of the above, in such situation, it is difficult for this court that there are reasonable grounds to believe that she is not guilty of such an offense and that she is not likely to commit any offense while on bail. Next one is the Section 37 requires that courts has to have a reasonable grounds to believe that the accused is not guilty, prima facie guilty. And in this court could not, Chitur is not able to find that the petitioners is not prima facie guilty. At this stage, the prayer for bail completed. Petitioner. Prayer for bail, prayer for release of the accused on bail cannot be accepted. In view of the bail application stands rejected. At this stage, sorry, it's the requirements of the law. We have human approach, as a human approach, we feel for you, for the kids, but then NDPS
I understand.
bail petition is still disposal. I think we'll have to correct something. We will just say. Just take a 5-minute break. We'll just say 5 minutes break. 5 minutes, come back. How long will it take?
I will take much time.
Okay. There's nothing much there. 164, how you can rely? You want that the trial courts ought to have relied this 164 statement. Is it a ground? I don't think
Yes,
so.
because say your lordship, there is a documentary evidence is there, but the trial court.
No, what is documentary evidence? 164, it's a PC Act. Huh? It's under PC Act.
No, in the IPC only, because the person is related to the person who is already deceased. It covers only the person.
So only IPCA.
Yes.
A procedure, nothing remains. Withdraw. We'll see.
This lordship.
Yes, madam.
Yes, lordship, on the other day, I have read,
Paper book.
yes, the paper book, yes. Now come to page 266. This is the prosecution, the witness number 7, who is the brother of respondent number 8.
Page
266.
266. 266.
Yes, your lordship. He is Numpowati. He, along with prosecution witness number 6.
Page 266.
Mm.
Who is he?
He is the brother of respondent number 8. He, along with his sister, prosecution witness number 6, paid 6 lakh to respondent number 2 by executing an agreement. So, Lordship, I may be allowed to read his deposition before the court. On oath, I am a businessman running transport agency in Mokokchung. I know this case relating to NPSC scam. My brother accused Imosamen is a graduate who applied for the post of ESC, DSP, and allied services. Accused Imna Onen demanded rupees 10 lakhs for the post of ESC, DSP, or allied service for my brother accused Imosamen. However, I have paid rupees 6 lakh in cash to accused Imna Onen for my brother along with my sister Achila. Out of this money, my brother Imosamen was expecting to get some post through NPSC after he informed to his brother. The rest I have nothing to say. Close. I say that prior to my payment of rupees 6 lakhs to Imna Onen, accused Imosamen had no material point of time in induce or pressurize me to pay the said amount to accused Imna Onen. Close by
Just wait. Imna Onen.
yes. Imna Onen is respondent number 2.
Okay,
And Imosamen is respondent number 8.
okay.
Yes, and the prosecution witness number 7, he is the elder brother of Imosamen, respondent number 8.
Imo Samen.
Yes,
Both these are little confusing.
yes, the name.
Immonasen and this Imna
Imna Onen,
Onen is
respondent number 2.
he's a public servant.
Yes, your lordship.
So why no PC?
Yes, he is. PC is also there, your lordship. Except only Imosamen, RA.
He's the official.
He is, yes, he is the LDA in the NPSC. Yes,
LDA.
yes.
And his mother,
Is the deputy secretary.
she expired.
Yes.
Respond number, accused number 4.
Yes.
Huh?
4.
Accused number 4 or respond number 4?
Respondent number 4.
Okay. So now LDA, na?
Yes,
LDA and NPS.
NPSC.
NPSC. Son of R4 who expired. He's the only government servant.
No,
R2.
your lordship.
R2 is the only government servant.
No, lordship, even R1, R2, R5, R6, R7. Only R8 is not a government servant, only
Okay.
R8.
So all
The rest are under PC also.
only
R8, yes.
R8 is
There is no PC Act.
not a government servant.
Yes.
Okay.
R3.
R3 also.
Yes, R3, yes.
Madam, tell us correct position.
Lordship.
We still confuse the name of this, then if you are making a incorrect thing, facts,
Lordship,
it will be difficult for me.
yes, that
for
would be
this
seen from
And
page
R
10.
two was a temporary employee, LDA,
court.
not a regular employee.
What are the section?
Lordship, the section is under section 34, 120B for
Just wait. Huh?
different section has been looked
Just
against a different person. So that one will be seen in page 10. Page 10.
Okay. Page 10. Accused number 6 and accused number 2. Huh?
Lordship. Yes. Accused number 2 and
And
accused number
Panggil Jamir.
Yes.
Who is he?
And Panggil Jamir, he is the father of R2.
Huh?
This appeal, number 6 here is R3. R3.
We'll go by the accused number. Huh?
Lordship. These are the accused number as per the charge sheet, but your Lordship, as per the judgment, the respondents.
Charges were framed under.
The charges were framed under 34, 120B, 409, 511.
All sections.
Yes, different sections were booked against different accused.
Yes.
Yes.
Different region.
So Lordship, come to page 266. Proposed by Momi. The amount of ₹6 lakh paid by my sister and myself to Inna Onan was arranged in the following manner. I myself raised 4 lakhs and 2 lakhs by one of my uncle, Talitushi. I'm aware of the fact that when the amount of ₹6 lakh was handed over to Inna Onan, in agreement for loan for the said amount was drawn up between myself, my sister, and Inna Onan. I'm not sure where the said agreement is, but I think I have kept at home. It is correct that in substance, the loan agreement states that my sister and I had advanced the amount of ₹6 lakh to Inna Onan as a loan and interest at the rate of 5 per month. The amount of ₹6 lakh loan to Inna Onan has been returned to me. That is to say, the entire amount of ₹6 lakh to me along by Inna Onan. I'm aware that in terms of law, the person giving the bribe or illegal gratification is equally criminally liable as the person receiving the bribe or illegal gratification. I agree to the suggestion that in terms of law, both persons or persons giving or receiving bribe or illegal gratification should be arrested and proceeded against. I have never been arrested by the investigating agency in connection with this case. The transaction was arranged by Inna Onan, my brother, myself, as well as my sister, Temsu Chila. Re-examination. The purpose of executing loan agreement is to secure the post of ESC, DSP, or any allied service for my brother accused Inna Imosanen. So, Your Lordship, even prosecution witness number 6 and number 7, that categorically stated in the deposition before the court, as well in the cross-examination, they have stated that the purpose for entering into a loan agreement was for the purpose of to secure the ESC, DSP, and allied service for the brother Inna Imosane, Your Lordship. So, Your Lordship, even
Is there anything to show that there is a demand or acceptance?
Lordship, all the documents, everything has been exhibited. So I'll show the exhibits of.
So can you show that there's a something evidence that there was a demand and there was
Yes,
an acceptance?
in the Lordship, in the statements, even in the confessional statements of the accused Imosanen as well as Inna Onen, even the confessional statement of the brother of R8. Even in his cross-examination before the court also, they stated that Imna Onan demanded money, Lordship.
Is there, apart from that, is there any proof?
Yes, the proof is that, so Lordship, the proof is that, I'll take you to Lordship, page
No,
276.
you continue, I'm just asking.
No, page 276, that is the Caesar that was exhibited by the IO. Page 276.
Two 760 is something different.
Page 276, this is the deposition of witness number 10, Mion, and he is the assisting IO, Lordship. Yes. All the documents, everything has been exhibited before the court. Lordship, I may be allowed to read the first paragraph. I have been functioned as DSP, additional SP in the Vigilance Commission for the last such and such. FIR was filed in the Vigilance Police Station based on the publication in the newspaper and also based on the instruction of state government with respect of NPAC scan against accused in Naonan and several others, including controller of examination. Exhibit P9 is the sumoto FIR. I'm also one of the assisting IO of this case. Initially on 2605, I have raided the private building of accused and Pangar Jamia, which was occupied by accused in Naonan. A lot of incriminating documents were recovered during the search, which are listed in Caesar memo. This Caesar memo contains steno notebook, personal diaries, bank accounts, application form, agreement signed in non-judicial papers, ethnic card form in advance. Exhibit P10 to P13 are the Caesar memo prepared by me, which bears my signature. Exhibit P10 bracket A is the shorthand book seized by me, which contain recordings of the transaction made between Imna Onen and the following person, namely Imliko Kla, 5 lakh paid, Imosanen, 10 lakh not yet paid, Sapose, 7 lakh paid, for Tinowati, 2 lakhs not yet paid. The rest are names and address of other person. Exhibit P10B is the loan agreement for rupees 6 lakhs between Imna Onen and A. Wati Ponjin, elder brother of Imosanen. Exhibit P10C is the same agreement produced by A. Achila Ponjin, elder sister of Imosanen, during her examination. So, Your Lordship, Exhibit P10A, P10B, and P10C. These are the agreements, Your Lordship, that has been executed between Imosanen and the prosecution witness number 6 and number 7. All this has been exhibited before the court, Your Lordship.
Then ABC.
Yes, ABC, yes. Then, Lordship, I may come take you to the position of prosecution witness number 9, who is the magistrate who recorded the confessional statement of the accused. Page 273. Because her deposition becomes crucial. Page 273. She said, I may be allowed to read. On oath, I was posted in Kohima as magistrate first class from 1996 to 2006. In the confessional statement of some accused person in two to three occasions. I have recorded the statement of accused Tiniwati, Imna Onen, Dem Sichila, Immosanen, Ewati Ponchen, Impondong Kumer, and Zaponse Santam. The accused person admitted their guilt by confessing that they had transacted the money between them for getting apartment through NPSC. Before recording the confessional statement, I have given them sufficient time to refresh their mind for full reflection, and I have explained to them in the language things understand that your confessional statement will be used against them if so confessed. And the accused person voluntarily confessed the offense while recording the confessional statements. No police personnel were present in my courtroom. I, along with the accused person, were present. Exhibit P1 to P8 are the confessional statement of the accused person recorded by me, which bears my signatures. The confessional statements of the accused person are voluntarily made by the accused person, admitting the commission of offenses, and this being the judicial confession are the strong evidence against the accused person. first by Ezimomi. I recorded the statement of Inna Onen, not Mrs. Achila and Mr. Evoner. I recorded the statement of accused Inna Onen on 28/6/2005 and 29/6/2005. I recorded his statement in courtroom, and he, along with others, was sitting outside the courtroom. When I called his name, he was brought by my peon, after which I recorded his confessional statement. I used the standard form for recording the statement of not only Inna Onen, but other accused persons too. I have stated in my examination in chief that when accused Inna Onen was examined, there were no police personnel inside the courtroom. I did not ascertain whether there were any police personnel outside the courtroom. I do not ascertain whether the accused Inna Onen was produced from judicial custody or police custody. Since the case originated from vigilance, the accused Inna Onen was produced in my court for recording his statement. He can be said to have produced from police custody. I'm not aware that on 28/6/2005 as well as 29/6/05, the accused Inna Onen was produced in my court for recording his confessional statement. I do not agree to the suggestion that my signature in the confessional statement of accused Inna Onen can be read as 24/6/05. Agree to the suggestion that the figure 8 written by the accused and figure 8 written by me are no resemblance whatsoever on the second day. The accused himself on 29/6/08 had come to me for further statement, which he could not complete the other day, though the accused was interpreted. I do not ascertain as to who produced him on the second day. I am not aware that the accused Inna Onen was also produced before them at the CJ Kohima for recording his confessional statement. I gave the accused Inna Onen about an hour or so for full reflection, and for the purpose, I took take the accused in the room of the prosecuting inspection. So, Your Lordship, even here also the magistrate has given about an hour to accuse respondent number 2 for his full reflection, Your Lordship. So if we, even in the next page, that is for Saponse, the magistrate has stated that she has given about 30 minutes for full reflection to respondent number 1 for R1. So normally, Your Lordship, the last page, the cross-examination, the last one, I may just skip, Your Lordship, point 1. It is correct to say that I have recorded confessional statement.
He was taken to room of the prosecuting inspector.
Lordship.
He was taken to the room of the prosecuting inspector. Last line.
I give the accused in about an hour, and for the purpose, I take the accused in the room of the prosecuting inspector. Yes, Lordship. Yes, that is what she has stated. But Your Lordship, for full reflection, she has given about an hour to Inna Onen, to respondent number 2.
In the room of the inspector.
That is what as per the statement.
He's not the inspector, police inspector, it's a prosecuting inspector.
Prosecuting only, Lordship. Prosecuting inspector. Then Your Lordship come to the page 275. One, it is correct to say that I have recorded the confessional statement of accused Imo Sanen under section 1642. I recorded the charge sheet confessional statement on 8/6/2005. 3. It is correct to say that I recorded the confessional statement in courtroom. Come to point 8. It is correct to say that there were no other person in the courtroom at the time of confessional statement. 9. It is correct to say that I have explained to the accused both in English and Nanganese so that he could understand what he was not bound to make the confessional statement. If he makes, it might be against him. 10. It is correct to say that the accused was brought before me in the first office hour, and I have given him about 20 to 30 minutes for full reflection. 11. During the period of full reflection, I have put the accused outside my courtroom, but I did not know where he spent that time. 12. I agree that 20 to 30 minutes time is good enough for full reflection. 13. It is correct to say that I have recorded the confessional statement of the accused in my own handwriting entirely. 15. I agree that I have complied to the provision of section 164 CRPC while making the confessional statement. 16, it is correct that the entire handwriting is in the confessional statement are mine. 17, I think that for footnote memorandum in the confessional statement satisfy the provision of law. So even the person who recorded the confessional statement says that he has given sufficient time to the accused person.
So in chief, you said 1 hour and the cross, you said 20 to 30 minutes.
Lordship. So your lordship, for
Which one is correct?
your lordship, because I spoke on for one person, she gave it 1 hour. For another person, she gave it 20, she gave it 30. So your lordship. So 20 to 30 minutes are quite enough for full reflection of the mind, your lordship.
According to her, according to the magistrate.
Yes, yes, lordship.
Is it according to the law?
Lordship, even according to the law also, because your lordship, there is sufficient enough, your lordship. Because the person, whatever they are submitting before the court is voluntary.
And then you are putting the person in the room of prosecuting
No, just
inspector.
because like they were placed in the prosecuting witness does not mean that
You could have put them in some other room.
lordship.
You could have put them in some other room. Why inspector?
But
I
just
mean,
because-
the
But putting them in that
prosecuting inspector.
cannot brush aside the voluntariness of the truthfulness of the
But he may have some before the prosecuting inspector, in the room of the prosecuting inspector, he may not have that proper reflection. Mine would be something else.
lordship, but we have
So
to,
that is the reason it should not be before the police.
yes, but we have to take,
Prosecuting inspector is equally, you are prosecuting the accused.
lordship, again, come to the
So
the
you
impingement.
have to see whether this enough. Your perception of 20, 30 minutes enough is maybe,
Yes, that is enough.
maybe it's your perception.
Yes,
But under the law, whether it could be treated
that is
as
up to your lordship.
not
Yes,
me,
up to
not
your
me,
lord-
it's as per the law.
Yes,
And then when you are giving a person to for reflection, you have to have a atmosphere, something other than definitely not before the police. But prosecuting inspector is a person
lordship,
that will determine, we'll see.
yes. Lordship, come to page, the impugned judgment that is at page 41. It's out
41.
on page 41.
41.
Yes. The judgment dated is 12/5/2016. So I may take you to the findings of the,
Page 41.
yes, page 41. This is the judgment.
Yes.
I may take you to lordship to the findings of the learned trial.
No, this is your ground, I think. Page 41.
No.
Page 41 is your grounds only.
Page 46.
Huh?
Page 46.
46.
Yes.
Ah. 46, 47, 46.
Yes, yes. So lordship, I may come to the findings that is at page 197.
See, this is PW, which 275 is,
Lordship,
page 275
275.
is a cross.
Yes, yes, it's a cross of
PW9, PW9.
Yes, yes, the magistrate.
Magistrate,
Yes, yes.
okay. Let us read, we cannot read the whole.
Yes, yes, I'm not, I'll
You just
give-
point out.
Yes, 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 where are the relevant points?
Relevant paragraph,
Yes, yes, yes.
relevant
Yes,
page, that's all.
page 197.
Hmm.
Yes, second para. The findings of the learned trial court,
90,
197.
black or it's written in bold or
The bold one,
97,
yes.
yes.
The second para, from the deposition as recorded will show that
Just wait.
second para, your lordship. from the deposition as reported will show that payment as deposed was loan with agreement to gain the interest was made.
Second para.
Yes, yes. From the deposition.
Hmm.
From the deposition as recorded will show that payment as deposed was a loan with agreement to gain the interest was made, and the fact remains that no NPSC question papers have been provided by accused IMNA owner to anyone. Recovery of diary and written deed as both and other entries of name has to be corroborated to other evidence which is missing in present given facts. So what the trial court says that though there was a written agreement, there is no exchange of supply of question papers. So these are missing. That is what Lordship, the trial court came to a finding. Then come to the Lordship, page 201. Page 201, second para. So also coming to the question of seized diary, apart from circumstantial evidence with regard to the articles seized, which are allegedly incriminating, reference may be made to the principles laid down by the Supreme Court in such and such. And then his conclusion was in the third para, a conspectus of the above decision makes it evident that even correct and authentic entries in the book of the account cannot, without independent evidence of the trustworthiness, fix a liability upon a person. So, despite of the incriminating articles seized from the house of respondent number 2, the learned trial court says that these are all circumstantial evidence. It needs to be corroborated with an independent evidence. Then, Lordship, we come to page 203. The last para. Therefore, considering the detailed deposition statements of the PW as recorded in details herein and above, and on perusal of the evidence placed on record, I am of the opinion that the prosecution, in given circumstantial evidence, in absence of reliable word corroborated evidence, and considering the settled law as discussed herein and above, and upon hearing the parties, the prosecution failed to bring home pointing guilt of the accused person beyond all reasonable doubt in all the charges so framed, to which I hold the accused person entitled to benefit of doubt on the account of charges. Coming back to the arguments made in recording of the confessional statement made by the accused person under 164 CRPC, details of PW9 GMSC depositions are taken into consideration. So, Your Lordship, what the trial court says that all these are circumstantial evidence without any direct evidence or documentary evidence. Then Lordship may come to the relevant page, that is at page 209. The 209, the second para. Coming back to our case, PW9 learned GMFC deposed that she remember taking accused IMNA owner to report his statement on 28 and 29, 6-5 in the court of GMC Kohima. He was lodged at SP Kohima, and at the time of confessional statement was reported on 28 and 29, 605. PW14 deposed to say that it is correct to say that I had taken accused upon sale from Vigilance Office to the court of GMC for recording confessional statement. I have also perused the case report, and in respect of accused IMNA Seme was reported on 8605, and accused Achila and A. Pangar confessional statement before GMSC was reported on 9605. Accused Aponse Santam on 15605 or accused Inawati on 13605. Accused Imna Onen on 286, and accused Impon Longkumar was reported on 3605. PW9 deposed that I did not ascertain whether there were any police personnel outside the courtroom. I did not ascertain whether the accused Inna Onen was produced from judicial custody or police custody. Since the case originated from vigilance, the accused Inna Onen was produced in my court for recording the statement. And in her cross-examination, it is correct to say that the accused was brought before me in the first office hour, and I have given him about 20 to 30 minutes for full reflection. During the period of full reflection, I have put the accused outside my courtroom, but I did not know where he spent that time. I agreed that 20 to 30 minutes time is good enough for full reflection. And from the deposition statement made by JMFC before this court, it is clear to conclude that accused were produced from police custody and on the day of production, after giving only 20 to 30 minutes or so, JMFC recorded the confessional statement of the accused person in contrary to the application of section 164 of CRPC. When accused is produced for recording confessional statement, JMFC has to advise the accused about the period made by the IO of the case and has to be sent back to judicial custody, giving at least 24 hours for proper reflection by the accused as observed in Sawan Singh Rattan case, and the same was found absent in the present given case as JMFC after giving 20 to 30 minutes or so, and on the same day of the accused production, before JMC, without ascertaining from whose custody accused was produced, recorded the confessional statement of the accused person. We recorded, and in given such facts and circumstances, the same cannot be relied upon by this court as correct proposition and interpretation of section 164 of CRPC as interpreted above. I have also perused the defense statement as recorded under 313 of CRPC, and accused Saponse Santam denied any transaction and stated that he was threatened by the investigation and compelled to make such a statement. Accused Innocent name also stated to have confessional statement recorded while he was under vigilance custody and was forced to make statement. Accused Inuwati denied to have made any agreement for payment of rupees 2 lakhs. Accused Indukon Longkumar defend the same as non-transaction only, and in absence of his father-in-law, he was asked to sign a loan agreement in the name of his father-in-law. Accused Imna Onen denied to have collected any money nor have passed question paper in advance, and denied any agreement, but was forced by vigilance to admit. Accused N. Palmer admitted to have taken loan, and the same has been said to have been returned, having no connection to NPSC. Now, Lordship may come to page 211. 211. The first paragraph, 5th line from the bottom. Accused Takasashi, Lordship. Accused Takasashi denied to know any transaction taken place between Imna Onen and accused Saponse, and accused Imna Onen stated to have no idea about demand of rupees 10 lakhs and payment of rupees 6 lakhs being made to accused Imna Onen, but he was forced to make confessional statement while he was in custody under vigilance. Thus, given the nature of the case and the defense statement as reported under section 313 of CRPC and the process adopted by the prosecution while reporting the confessional statement, while accused were in the custody of the investigation agency, which reflects inducement and threats as stated, and therefore the prayer of learned public prosecutor to convict the accused person on grounds of confessional statements as reported under section 164 of CRPC cannot be a ground as the same failed to taste of law. As such, I am not inclined to convict the accused person based on the confessional statement, given the fact of the case as observed herein and above. Therefore, upon hearing the parties and on perusal of the case report and the reasons and findings as placed herein and above, I am of the considered opinion that the prosecution in given circumstances failed to bring home to prove the guilt of the accused person beyond all reasonable doubt, and accordingly I rendered the order. In the result, accused Saponse Santam, Imna Onen, and Pangler Takachilla, Takasashi, Inuwati, Inkondong Kumar, and Imon Sanan are acquitted on benefit of doubt. So, Your Lordship, the trial court did not rely on any of the documentary evidence, Your Lordship, and even the position of the IO as well as the assisting IO, saying that the confessional statements were taken while they were in the judicial custody, Your Lordship. All those things has been brushed aside. So, Your Lordship, my grounds for this appeal, page 40, Your Lordship. I'll just read few of my grounds and then I'll submit some citation, Your Lordship. Lordship, that is at page 40.
Yes,
Your Lordship, one, further the learned trial court committed manifest illegality in holding that the payment of money to accused Inna Onan was loan with agreement to gain the interest and the recovery of diary and written B as both, and other entries of name was not corroborated, and the same is missing in the present given facts. This finding of the trial court is not sustainable in the eye of law, as the seized document contains the facts and figures disclosing reflection of what really transpired in relation to the transaction indulged by the accused persons to purchase question papers for NCS and Allied Service Exam 2005. As such, the judgment and order dated 12/5/2016 passed by the trial court is liable to be interfered with. 3. Further, the trial court has committed illegality in acquitting all the accused persons, giving them the benefits of doubt without considering the voluntary confessional statement by the accused person before the magistrate. The confession has unfurled the whole story of the prosecution, but without appreciating all the evidentiary documents which corroborated the statement of the PW as well as the accused person. Then 4. Further, the trial court has committed grave error in holding that the prosecution case is based on circumstantial evidence, and in absence of reliable corroborated independent evidence, a strong suspicion cannot replace legal evidence. The trial court failed to appreciate the material evidence which showed the concert and connection between the accused person charged with to procure question papers of NCS and Allied Services Exam 2005 2 to 3 days before the exam. The confessional statement of accused person was fully corroborated by sets of documentary evidence. As such, the prosecution case is not based on circumstantial evidence, and non-examination of independent witness does not have adverse impact on the prosecution case. As such, the impugned judgment and order is liable to be quashed and set aside. 5. Further, the trial court has committed illegality by sidelining all the evidentiary value of the prosecution witness and the confessional statement of the accused person. The confession was recorded in accordance with section 164 CRPC by the magistrate, and as such deserved to be given due consideration while appreciating the evidences relied upon by the prosecution. As such, the impugned judgment and order dated such and such is liable to be set aside and quashed. Further, the trial court has committed illegality without appreciating the fact that the magistrate is satisfied that the confession was voluntarily, though the confession was retracted when the accused were examined under section 1313. The confession is corroborated by other evidence, therefore legally acceptable evidence against the accused person. But the trial court failed to take this aspect into consideration and acquitted the accused person. Further, the trial court had committed illegality and fails to apply its judicial mind and wipe out the facts and held that the accused person confessional statement were recorded by the GMFC after giving only 20 to 30 minutes for full reflection, which is in contrary to the application of section 164 of CRPC. The trial court failed to appreciate the fact that the ingredients of section 164 were fulfilled by the magistrate and that the confession is corroborated by other materials, evidences, and no contradiction in the evidence, both oral as well as documentary, when compared with confession made by accused person. And despite of this corroborated evidence, the trial court concluded that the prosecution failed to bring home to prove the guilt of accused person beyond all reasonable doubt. As such, the judgment and order dated 12/5/2016 is bad in law, not sustainable in the eye of law, and liable to be set aside and quashed. So, Lordship, regarding the retraction.
whether these exhibits were fruit.
Yes, Lordship. Because our Lordship. Lordship, it has the exhibits has been shown before the court.
It is no,
Seven-
before the court, whether it was fruit or not.
It will be proved. If it is not objected to by the accused, Lordship, it is presumed to be proved, Lordship.
I don't think. So.
Because the accused has to prove that. So, Your Lordship, regarding the infractions of the confessional statement.
To rely on the documents, you have to prove it. Just placing it before the exhibit, putting it as an exhibit will not be enough. It has to be proved. You have not shown anything as of now that these documents will prove. Unless it is proved, with the question of
Lordship,
just exhibiting will not be enough. Anyway, we'll come to you. That you just you proceed. That will be strange. Documents not proved has to be relied.
Lordship, I'll show you that.
Okay, proceed.
Lordship, thank you, sir.
Okay.
Because logic, based on citation 2001-6 SCC 550.
Just wait.
Motion
2000.
2001-6 SCC 550. It's the case of state of Tamil Nadu versus PT. At paragraph, yes, motion. Para 10, starts from para 10. Para 10, motion. If the confession recorded by the judicial magistrate as from A2 cannot, for any reason whatsoever, be used by us. It would be an exercise in futility for the state to endeavor for reversal of the order of acquittal with the help of the remaining evidence. So we would first consider and decide whether we can rely on that confession. 11. The judicial magistrate will record the confession of the second accused in exhibit such and such, had written down the statement running into several pages containing many vivid details. The narration included how A2 started working as a watchman in the house of the deceased, how A1 Jabaras injected the idea of taking away the huge amount of cash kept with the deceased, how the three accused jointly prepared the plan to kill the two ladies to pave the way for burglary, and how they executed the design scheme, etc. 12. Learned judges of the High Court declined to act on the said confession, mainly for two reasons. First is that the confession was retracted by the matter thereof, and second is that the recovery of articles was made prior to the confession. We may state at the outset itself that both reasons are too insufficient for overruling the confession. 13. It is not the law that once a confession is retracted, the court should presume that the confession is tainted. As a matter of practical knowledge, we can say that a non-retracted confession is a rarity in criminal cases. To retract from a confession is the right of the confessor, and all the accused against whom confessions were produced by the prosecution have invariably adopted that right. It would be injudicious to jettison a judicial confession on the mere premise that its matter has retracted from it. The court has a duty to evaluate the evidence concerning the confession by looking at all aspects. The twin test of a confession is to ascertain whether it was voluntary and true. Once those tests are found to be positive, the next endeavor is to see whether there is any other reason which stands in the way of acting on it. Even for that, retraction of the confession is not a ground to throw the confession overboard. Then the next tradition is 2014 6 ACC 59. 2014 6 ACC 59 is a
Just wait.
2014 6 ACC 59. Lordship, maintenant to para 24, page 72. Para 24.
Yes.
We must now come to the retraction. It is argued, however, that accused one Senthil Kumar has retracted his confession, and hence it has no evidentiary value. It cannot be relied upon. It is not possible to accept this submission. Retraction does not always dilute or reduce or wipe out the evidentiary value of a confessional statement. Quite often, retraction is an afterthought. It could be the result of legal advice or pressure exerted by those whose involvement may be likely to be disclosed or confirmed by the confessional statement of the accused. Therefore, in each case, the court will have to examine whether the confession was voluntary and true, and whether the retraction was an afterthought. In Kalawati versus State of HB, this court stated that the amount of credibility to be attached to a retracted confession would depend upon the facts and circumstances of each case. Again, instead of Tamil Nadu versus Kuti, this court stated that a retracted confession may form legal basis for conviction if the court is satisfied that the confession was true and was voluntarily made. Following this judgment is Yaqut Abdul Razak Memon, this court held that where the original confession was truthful and voluntary, the court can rely upon such confession to convict the accused in spite of the subsequent retraction and its denial statement under Section 313 CRPC. The law is thus crystallized. A retracted confessional statement is therefore not always worthless. We have no hesitation in reiterating that accused one Senthil Kumar confessional statement was recorded after following the correct procedure. That is, it was voluntary and truthful. That accused one Senthil Kumar was not forced or compelled to give his statement, and that the retraction of the said statement is clearly an afterthought and should be ignored. So your lordship, my submission is that whatever the accused they have.
Facts and
Yes,
circumstances.
yes, but they have,
It's just not because it has been retracted, you cannot rely.
yes, lordship.
That's all.
Yes, and even the prosecution witness, number 6 and number 7, who entered into agreement, they are the eyewitness, your lordship. They have categorically stated that they pay the money to respondent number 2 in order to procure the patient paper and to secure job for the brother, your lordship. So everything, all the chains of
Moreover, whether it was made voluntarily.
yes,
Voluntary.
yes, your lordship.
When we confessional statement is voluntary,
It's a-
therefore this
yes.
reflection and everything is
Lordship,
required to be
so
looked into.
my prayer is that your lordship, the impugned judgment and order should be quashed and the equity may be reversed. That's my prayer. Such a blessing.
So there is no proof of documents. No, the exhibits were not.
Lordship, the IO of the case, they have exhibited to the
The
court.
exhibited, but it
Yes,
has.
it is the accused who has to, the counsel of the accused, they have to disprove
It
it.
is the
by-
prosecution who has to prove their documents.
So we have.
The burden doesn't shift.
No, the burden does not shift, but your lordship, it is the accused who has to put cushions on the prosecutor in order to demolish that
Because
evidence.
this documents, confessional, you're trying to derive from those documents, which has admittedly not been proved.
Lordship, they have never,
What are the findings by the learned trial court on that? What are the documents,
No,
whatever
that's-
there's nothing, not on the,
lordship, so far I have seen,
there is.
it is that. Otherwise, your lordship, even,
I'll take your lordship.
yes, otherwise, my view, my submission.
Yours is only that there is a confessional statement, though it has been retracted,
Yes,
just because it has not been retracted, just because it has been retracted, doesn't mean that you cannot rely on it.
lordship.
Even if it is retracted, the statement can also be relied.
Yes,
Huh?
yes. And regarding about the exhibit, your lordship, it is the accused who has to disprove it, because what they did.
Show me the law.
They did not disprove.
You find out the law.
The court take cognizance of.
You
it.
want that the burden shifts. Once you exhibit, burden shifts.
Yes, it will be shifted to the accused to disprove it, your lordship.
This is beyond my knowledge. So as that. Once it is exhibited. And the prosecution has no need to prove it, burden shifts to the accused.
Because your lordship,
Defense.
the maker of the exhibit on oath and on cross-examination, they have stated that they have made the agreement. So it is the accused who has to disprove that it was not.
What is not proved, how can it be disproved?
So when they did not raise that question, your lordship, the court has taken cognizance of that.
So your only is that 164 retracted, could have been relied. That's all. Yes.
So firstly, your lordship, on the issue of the confessional statement. It is my case that the confessional statement in the first place is not a valid confessional statement.
Yes.
And secondly, it is a retracted confession statement. Two parts, your lordship. Two parts.
One is,
It is not a valid confession statement in terms of law.
yes.
And secondly, it is even otherwise, it is a retracted confession.
Okay.
Without wasting much time, your lordship, if you may take your lordship to the meat of the matter. Firstly, I am representing respondents 2 and 3,
Yes.
and I was representing respondent number 4 also. Respondent number 4 by order dated 27/6/17. She has been struck off.
You are 2 and 3.
2 and 3 now, 2 and 3. Respondent 4 has been struck off by order dated 27/6/17. Earlier, your lordship was remarking about the PC Act. Your lordship, no one can be faulted for listening to the grounds on which the appeal has been made and thinking that this is the proceeding under the PC Act. This is not the proceeding under the PC Act. First, First fatal flaw as far as the appeal is concerned. This is not a proceeding under PCI. This is not about giving or taking of bribes. The confessions which my another friend relies upon, it's all about bribes. Taking bribes to get some profit in the process. But that is not the case. What is the case, Your Lordship? The charge sheet was framed against respondents 2 and 3. What are the charges framed against respondent 2? Let's go to that. Respondent number 2 is at page 325. 325. Has your Lordship got 325?
Yes.
The charge framed against the respondent 325 is under section 511.
Where do you find it?
At page 325,
Yes,
at the bottom of the page, Your Lordship.
Yes.
This is against the accused Imna Onen
yes,
on the left. And the second, Your Lordship,
409.
511 and 409.
This is against
Respondent number 2.
two.
Respondent number 2.
Who is
The Imna Onen. Imna Onen.
LDA?
The LDA, the temporary LDA.
409. Yes.
409 and 511. Against the accused number 3, Your Lordship. That is at page 327. Against him, it is under section 34, 327. At page 327.
Yes.
327, sections 34, section 108, and section 511 IPC.
Yes.
So on the charges framed, Your Lordship, so that there is an easy reference for Your Lordship. With the statement that I have made in respect of these charges in my written argument, for easy reference, just in respect of these charges. My written argument is at page 407. At page 407. Just in respect of these charges, Your Lordship, then I'll progress to the other agreements. 407.
Yes.
407 is my written arguments. And the Lordship will turn to page 408. Lordship got 408.
Yes.
Come to the heading, Your Lordship, the case against the accused Imna Onen. In the middle of the page, has the Lordship got that?
Yes.
The case against accused Imna Onen, section 409, criminal breach of trust by a public servant or by a banker, merchant, or agent. The essence of this section is that the public servant in question must be entrusted with property or with dominion over property, and she commits criminal breach of trust in respect thereof. Section 5 is the attempt to commit the offense. So criminal breach of trust, Your Lordship, the essence is what? I must be entrusted with some property, and I must misuse that property in all the evidence which has been relied upon by the prosecutor. Any evidence at all to show as to what property I was entrusted with and how I misused that property. Nothing. Absolutely nothing. Then the case against the accused and Congress at page 4110, man. 4110. In the middle of the page again, no? Page 410. 410. In the middle of the page again. The case against the accused and Pankaj Abid.
34106.
Yeah, section 34, 108 and 511.
Yes.
The charges framed against the accused and Pankaj Abid, as will be apparent from the sections above referred, are that he entered into a criminal conspiracy with his son for procuring question papers for candidates. As such,
the accused N. Pankaj Jamil is charged with common intention, abetment, and attempt to commit offences. These offences are alleged to have occurred on 12/2/2005. For any other charges against the accused N. Pankaj Jamil to be sustained, since he is accused of common intention, abetment, and attempt to commit offence. These are the only sections against him, Your Worship. The charges against his son, the accused in honor, must first be established. In the instant case, the prosecution has miserably failed to bring home any of the charges against the accused in honor. Consequently, the charges against the accused N. Pankaj Jamil must also fail. So, in sum and substance, Your Worship, this is the defense which we have adopted. Now, if you may go to the statement of the assistant inspector, assistant investigating officer, that is NDPS, and this is the page 276. Much has been made by the prosecutor in relation to the evidence of this witness. One. At page 269. But the way the paperwork has been presented, Your Worship, it is one page is somewhere ahead of
269.
269.
PW2 9.
Yes, Your Worship, PW9. No, in this. There's some mistakes in the numbers apparently, Your Worship. Somewhere else is mentioned as PW10, but here it is mentioned as PW9. Your Worship can see that. Now, this is his examination in chief.
What is the name of that?
Mei Onen. Mineyonen.
Mei Onen.
Mei Onen.
Yes.
PW9 is examination in chief. Then, to the relevant portion, Your Lordship. Portion now at page 276. 276. Carries on to 276. Here he is shown as PW10. And again, the same person. May Onen. Now, if Your Lordship can turn page again to page.
Why this is so?
This is how the paperwork has been compiled, Your Lordship. I'm also at a loss to understand this.
What is this? Same person?
PW10. 276.
But different statement. Name is same.
Yes.
The statements are different. How we reconcile this? There must be a mistake in the name.
Must be a mistake. It is the same person, Your Lordship. It is, but Your Lordship, it may not be that much of a problem if I can take Your Lordship only to the relevant portion, where your Lordship's concerns about the exhibits, whether they have been used or not. That portion. So we take Your Lordship to that portion.
No, but the statements are different.
269. 269 is the first page, Your Lordship.
216 is that I joined in the business commission
Yes.
in the year 1996.
Yes.
Then this is that I have been functioned as DSP. Is a continuation or a different?
There's some mistake there.
This is by the IO.
Assistant IO. The assistant IO. Mr. May Onen, he was the assistant IO. And he is the one who effected the seizures that the prosecutor is relying upon.
But it has to be sorted out first. Same person, different statement. PW is also 1 is 9, 1 is 10.
Your Lordship, yes. Lordship, the record will be there before this court, Lordship. There is the original report.
You have relied both. I didn't notice that. PW9 and PW10 you have relied.
Yes.
You have shown the statement.
Actually, the magistrate who recorded the confessional statement.
Okay.
It must be.
Therefore, there are two
This
PW9.
typing mistake, it should be 10, no? Yes.
No, but what the lordship is saying is that even the contents are different. Look at the introduction part.
Yes, but maybe your lordship on different date he has been cross-examined. Not on the same date, on different dates.
No, there are two PWs, page 273.
273.
This is magistrate which you have relied.
Yes, this is PW9.
And page 269, it shows, also says PW9.
10. Yes. So neon name ought to have been PW10.
But this 9, there are two PW9.
Yes. 9 would be the magistrate.
And what about this?
Two,
May Onen?
he will be respondent number 10. I think there is a typing.
No, PW10.
Yes, typing mistake here. In page
No,
269.
that's what I'm saying. Maybe PW10, but PW9, there are two PW9 in this paper book. One is magistrate which you have relied, but same thing, page 269.
Yes.
It's also PW9.
Yes.
His name is the same that of PW10,
So it,
but different statement.
page 269 ought to have been PW10.
No, I joined in the Vigilance Commission. You have referred page 276
Yes,
as PW10.
yes.
You'll have to find out. Give it to our. Page 269 and page 276. You just find it out. Different statement, same person. And there are two PW9. Yes.
Yes, madam. So in the statement 276, the 276 statement, we can come to page 278 to 79.
Yes.
We can start from 1, 2, 3, 4, the fifth line. The witness, Your Worship, the fifth line from the top,
Page 278,
279.
79. It is,
Yes, the witness named in the CJ memo lives near the residence of Imna Onan, and he was working as an LD in the secretariat. The residence of the accused Imna Onan is a populated area, and it's correct that I obtained the signature of only one person in the CJ memo. So even with respect to the CJ memo, only one person.
yes,
Then, besides the statement in the CJ memo showing the articles, this is important, Your Worship. Besides the statement in the CJ memo showing the articles and the belongings seized, I do not have any other evidence to prove that the article and belongings of the accused belongs to Imna Onan and his family. Exhibit P10 is the short handbook of accused Imna Onan. The CJ and in their report was not reflected separately but contained, as earlier stated. I did not subject the document exhibited as Exhibit P10A to any authenticating process to establish the genuineness, ownership, and authorship of the documents.
yes.
So they rely on the CJ memo. So firstly, they did not comply with the requirements, only one witness, despite the area being a populated area. And all the documents seized, they did not subject the articles to any authenticating process, including the diary, which they alleged to have seen. Then, with regard to the confessional statement, now if you watch, you can turn to the next page, page 280. At page 280, have the Lordship got that? If the Lordship can come to the paragraph which starts with I remember, third paragraph from the top, I remember. I remember taking the accused Imna Onan to record his statement on 28/6/5. I personally, along with other personnel, took him before the court of JMFC Kohima to record his confessional statement. He was produced before the JMFC on 2 occasions by me. He was lodged at South PS Kohima. This is important, Your Worship. He was in police custody. He was not in judicial custody. It is a wrong statement for the prosecutor to say.
We have to read the full statement. He corrected himself.
You can reply. Please don't interrupt. Then reply after I finish.
Yes.
The fact of the matter is, he was lodged in South Police Station in March. At the time of the confessional statement, we recorded on 28 and 29/6/2005. And Your Lordship may also know the confessional statement was recorded.
This is a wrong typing also, right? Confidential statement.
It should be confessional. Your Lordship.
Confessional.
Yes. Should be confessional. And Your Lordship may kindly note on 2 dates, confessional statement.
28 and 29.
28, 29. After that, Your Lordship.
This is in respect of
It's one number 2.
2.
It's one
Okay.
number 2.
Okay.
The witness corrects himself that the accused was in judicial custody at that time. So he gave a correct statement. That's a different matter altogether, Your Lordship. But he admits that the accused was in police custody in South Police Station. And why the first part of his statement is correct, Your Lordship, the main investigating officer, the lead investigating officer, what does he say? Your Lordship, you may have the statement of the lead investigating officer, is PW15. PW15. Page 3110.
Three?
3110. At page.
Yes.
We find. Right. The cross-examination, Your Lordship, is at page 285. Here again, there's some mistakes in the placements of the documents, Your Lordship.
285?
285.
You are going back from 310.
Yes. And this is the cross-examination.
Okay.
And relevant portion is at page 286.
Huh?
Page 286.
This cross-examination.
Yes, this is cross-examination. So this should have actually been tagged together with the initial part. Page 286. Cross-examination at 1, 2, 3, 4. The statement at cross-examination 4. It's a Lordship got it?
Yes.
At page 286.
1,
2, 3, 4. I am aware that when the confessional statements of the accused were recorded, they were in police custody.
Where it is?
At page 286, the cross-examination question at number 4. Reply at number 4. 1, 2, 3, 4. The triple X markings are not sure. cross markings at number 4 from the top. 1, 2, 3, 4. I am aware.
Yes.
That when the confessional statements of the accused were recorded, they were in police custody. So this is the eye of the case, Your Lordship. So therefore, a confession in respect of a person who is in police custody is not a valid confession in the eye of law. Secondly, Your Lordship, the time frame which the learned prosecutor read upon, I will not go back to that again. There is not sufficient time as contemplated by law. Therefore, on that ground also, the confessional statements of the accused are not valid confessional statements in the eye of law. On these 2 points,
According to what should be the
at least 24 hours.
24?
At least 24 hours. And that the learned tribunal has taken that into consideration, which my learned friend herself read, at least 24 hours. And not only that, Your Lordship, if a confession statement is to be recorded, the magistrate must ensure that the person whose confession statement is sought to be recorded is not in police custody. That person should be in judicial custody. That person should be in judicial custody. That is established law. So therefore, apart from the retracted part, the confessional statements themselves are not valid confessional statements in the eye of law. And therefore, they could not have been acted upon. So therefore, though the trial court relied only on the retracted part, even the validity of the confessional statements, that is an issue. That was an issue. That is an issue even now. Now, what are the grounds that the state has taken? It was page 40 again. Just shortly, I just want to make a point here. Page 40.
Grounds of appeal.
Yes.
Yes.
Now, the first ground. The first ground is recovery of diary. Worship has got that in the first recovery of diary. And it's just recovery of the diary alone is a corroboration of facts. That's what the state wants to say. Recovery of diary alone. Then round 2, confession statement. Round 3, confession statement. Round 4, circumstantial evidence. Corroborated independent evidence. Nothing like that. Then round 5, confession statement. Round 6, confession. Round 7, confession. Round 8, the agreement to purchase. Now, as far as that issue is concerned, the learned trial court has examined all the evidence and come to a conclusion. And the conclusion is what, Your Lordship? Though the witnesses who were examined say that they were meant as consideration for illegal purpose, these were executed for taking loans, and loans were repaid. And loans were repaid. And that is the substance of the evidence which was read out by my learned friend. There was no evidence, there was no conclusive evidence, there was no direct evidence that money was paid for the purpose of illegal purposes, for getting some illegal gain. What was proved? Money was paid, loan was given, loan was returned. That was the finding of the learned trial court. Can that be faulted? Has the prosecution been able to place any evidence to even suggest that that finding is wrong? Nothing, Your Lordship. What are they relying on? The confession statements. Purely and simply the confession statements. And whose confession statements, Your Lordship? The brother and sister of the respondent number 8. Now, Your Lordship is aware, in terms of law, those who give the bribe are equally as guilty as the person who receives the bribe. The police did not arrest the 2 brothers. There is one, the PW numbers 6 and 7. And even in respect of the payment and recovery, Your Lordship, I'll not I'll take a lordship to the contradictory statements there by the brother and sister. They were not arrested at any point of time. They are equally as guilty, your lordship. If you are to go by the charges framed by the, or the arguments placed by the defense, they are equally as guilty. They were never arrested. No proceeding was initiated against them until 306 to make them approvers. And out of the blue, the appellants want to say that we are guilty. The state wants to say that we are guilty based on their statements. How can that be, your lordship? Is that the procedure prescribed by law? It is not the procedure prescribed by law. You don't take action against an accused person in terms of law, and you use his evidence to try and convict other persons in the course of trial. Is that a procedure prescribed by law? It is not, your lordship. My humble submission is that it is not. Now, if I may take your lordship to the findings of the Manoj trial. The findings starts actually from page 172. 172. Okay, lordship, come to page 172.
Yes,
Reasons and findings.
yes.
Reasons and findings. Now, your lordship, a whole discussion, an elaborate discussion by the trial court. You can skip all these pages, your lordship, come to page 170, 173, 174, 175, 76, 77. 177.
Hmm.
177, your lordship. Some discussion with you. Certain portions I'd like to refer your lordship to.
Yes.
Then, if the lordship will come towards the bottom of the page, which starts with, I was in the rating team,
Page
page 177. This is a discussion of the evidence.
77.
177. Yes, towards the bottom of the page. I was in the rating team. Towards the middle of the page, towards the a little lower than the middle of the page.
Hmm.
I was in the rating team.
Hmm.
I was in the rating team, which raided the building occupied by Imran.
Yes,
I-
yes.
I do not, exact numbers of serial memos, but as far as I recollected, I prepared one continuous serial memo for the entire recoveries. Exhibit P10A is a shorthand book of accused Imran. The CCA in this regard was not reflected separately but combined as stated earlier. I did not subject the document exhibited as Exhibit P10A to any authenticating process to establish the genuineness, authorship of the documents. Then it continues for your lordship. Exhibit T, P10C, Exhibit P11A are agreements for loans between Imna Onan and others. Exhibit P11E included Exhibit P11B, P11C, P11D related to banking transactions.
He took it for granted
They took it for
that
granted.
it's a genuine.
Yes, that's all. None of the documents seized was subjected to any authenticating process. Not only that, your lordship, in the trial court, just the CCA memo was exhibited. Then 177, 178. Then your lordship, at page 178, a discussion of a very interesting aspect of the matter.
Hmm.
In the middle of the page, till 2002. Have you lordship got that?
Yes.
178.
178.
178. The paragraph starts in the middle till 2002.
Hmm.
Till 2002, before KV Legacy joined as controller of examination, the accused Takachila was in charge of the confidential branch. At the time when the case was registered, the controller of examination, Mr. KV Legacy, was in charge of the confidential branch. Besides the controller of examination, I know only two persons, namely Mr. Changsu and Ms. Catherine, C3 C. Lothar, who were allowed entering into the confidential branch. Now, this is important, your lordship.
Hmm.
The confidential branch is the branch where all these documents are kept. Who was in charge of this confidential branch? None of the accused, including the respondent number 2. And the persons who are in charge have been mentioned. Then 178, 179, 180, 181. Again, at page 181, Your Lordship, the discussion of the evidence. Page 181. Page 181. Your Lordship, you kindly see the cross-examination by me. My name is reflected there. Towards the bottom of the page. Is the Lordship got that?
Yes.
I also did other investigation work till the completion of the case. I examined Mr. K.V. Legise, that is the controller of examinations, and Ms. Piholi and Ms. Silota. Though I examined K.V. Legise, the then controller of examination, he is not in the list of witnesses as he did not have any material evidence for the purpose of the investigation. He also did not have any complicity in the commission of which the case was registered. So this is the person who had control over the confidential branch. Then, Your Lordship, and if you can continue to page 183. Then cross-examination by Sri Y.I. Singh, and we can come to that portion.
Yes.
It is correct to say that the accused persons who made confessional statements, they gave the confessional statements while they were still in police custody. Then 184, 185, an elaborate discussion of the evidence, Your Lordship, 187, 188, 189, 190, 191, 92, 93. Again at 193, at page 193, Your Lordship. Towards the bottom of the page, I am aware. 193. The sentence beginning with I am aware. Towards the bottom of the page.
Yes.
I am aware that when the confessional statements of the accused were recorded, they were in police custody. Then at page 194, the next page. It is correct that none of the accused were actually caught red-handed at page 194. It is correct that none of the accused were actually caught red-handed in the commission of offense as alleged in this case. So no one was caught red-handed actually, only on suspicion. This is the discussion of evidence mentioned by the learned trial court. Then discussion of then page 187. Based on all these discussions, Your Lordship, the trial court comes to findings at page 187. 187.
187.
197. 197. The second paragraph. From the deposition as recorded, which show that payment as deposed was loan with agreement to gain interest was made, and the fact remains that no NPC question papers have been provided by accused in the honor to anyone. These are the findings of the learned trial court.
Allegation may be correct, but it has not been proved.
But the fact of the matter, Your Lordship, is no incriminating materials in relation to the accusation.
But diary and agreement, they've all been seized.
Yes, Your Lordship. No, seizing of the diary, seizing of the agreement by themselves do not prove guilty.
Now, that is one thing.
Yes. By themselves, they do not prove.
You may be correct, but it has been seized.
Yes, they have been seized. No doubt about that. They have been seized. Now, in addition to that, what should have been seized, or what the prosecution should have proved was that I was in dominion of a property entrusted to me by the NPSC, and I misused that property. And that would have become relevant in relation to the diary and the loan agreement. But nothing like that. Nothing like that. There is no evidence at all that the NPSC entrusted me with any confidential work at all. There is no evidence that NPC question papers were leaked. There is no evidence that I handed over NPC question papers to my other co-accused.
Apart from the actually what had happened, was it leaked?
No, it was not. Nothing was. How was it initiated, Your Lordship?
Like
The control of examinations.
in the other states happening.
Yes. So the control of examinations. He says that he approached him and said that we should supply question papers to him. That kind of a story started coming out in local papers. And because of the
I think nothing,
papers, soon notified was registered.
nothing has been proved that the question papers were supplied.
Yes.
Nothing is,
Nothing.
it's just a form has been seized
Yes.
from the office.
No form also has been seen. Nothing.
No, from the office.
No, nothing has been seized. From my residence, from the respondent number 2 and 3's residence, husband and wife. The respondent number 4 was working as a deputy secretary. So she had access to some NPC documents. That's all. So those documents were seized. Nothing else.
Is there anything to show that in the process any paper was supplied?
No, nothing. Nothing at all.
Attempt.
Not
Attempt
even-
has
not
been
even
made.
attempt. Worship off record, maybe a contemplation. Not even an attempt.
Yes, maybe contemplation.
So, Your Lordship, so from the deposition as recorded, we show that payment as deposed was low, with the agreement to gain the interest was made, and the fact remains that no NPC question papers have been provided by accused now. So this is a clear finding of the learned trial court. Clear finding. Then it continues, Your Lordship. Recovery of diary and written B as boss and other entries of names has to be corroborated to other evidence which is missing in present given case. In CBI versus V.C. Shukla. So this is V.C. Shukla is relied upon by the Defense Counsel of 76 has observed, this is the Hawala case, has observed that Section 34 Evidence Act lays down that entries in books of receipt regularly kept in the course of business are relevant, but such statement will not be sufficient to charge any person with liability. It has to show further by some independent evidence that the entries represent real and honest transaction and that the monies were paid in accordance with those. So it must be corroborated. Merely exhibiting is not enough, Your Lordship. And the entries must be proven.
Yes.
Then, Your Lordship, again, more discussion of the evidence, Your Lordship. Page 201. Page 201. So also coming to the question of seized diary, apart from circumstantial evidence with regard to the article seized, which are allegedly incriminating, reference may be made to the principles laid down by the Honorable Supreme Court in the V.C. Shukla case. In this case, the Supreme Court was dealing with the Hawala scam and the diary seized in connection with the said case. Dealing with the relevance of the diary seized under the Evidence Act, the Honorable Supreme Court held that it is necessary to have independent evidence as to the trustworthiness of entries in the diaries with personal liability. In the case at hand, the aforesaid principle would apply to the diaries and tabulation register allegedly seized. The relevant paragraphs are reproduced hereunder, which are paragraphs 34 and 39. So paragraph 34 and 39. Then a conspectus of the above decisions makes it evident that even correct and authentic entries in the books of account cannot, without independent evidence of their trustworthiness, fix a liability upon a person. Then, Your Lordship, we continue. 201, 202, then 203. The last paragraph.
203.
Yes. Therefore, considering the deposition statements of the PWs as recorded in details here and above. And on perusal of the evidence placed on record, I am of the opinion that the prosecution in given circumstantial evidence, in absence of reliable word corroborated evidence, and considering the settled law as discussed herein and above, and upon hearing the parties, the prosecution failed to bring home pointing guilt of the accused persons beyond all reasonable doubt in all the charges so framed, to which I hold the accused persons entitled to the benefit of all the account of charges. Then further discussion, Your Worship, 204, 205, 206, 207. Then 207, Your Worship. 207. Your Worship, come to 207.
Yes.
The paragraph which starts from besides.
Hmm.
Besides various decided cases as relied upon by the Indian Defense Councils, in the case of such and such, the Honorable High Court at paragraph 17 stated that before proceeding to record the confessional statement, a searching inquiry must be made from the accused as to the custody from which he was produced, and the treatment he had been receiving in such custody, in order to ensure that there is no scope for doubt of any sort of extraneous influence proceeding from a source interested in the prosecution still lurking in the mind of the accused. It is evident from the evidence that the magistrate did not make any such searching inquiry to ascertain how long the accused had been in police custody and the sort of treatment he had been receiving from the police. Then, in the case of Sarwan Ratan Singh, 1957, Supreme Court, a very old case, the Supreme Court clearly held that a confessing accused generally need to be given 24 hours time. This case is still good law, Your Lordship. It has not been overruled. In fact, it has been relied upon in subsequent cases also. 24 hours to have proper reflection on the warnings given to him, so that such an accused person does not make any confession under any kind of influence whatsoever. The relevant part is released below. The whole object of questioning to an accused who offers to confess is to obtain an assurance of the fact that the confession is not caused by any inducement, threat, or promise, having reference to the charge against the accused person as mentioned in Section 24 of the Indian Evidence Act. There can be no doubt that when an accused person is produced before a magistrate by the investigating officer, it is utmost importance that the mind of the accused person should be completely freed from any possible influence of the police, and the effective way of securing such freedom from fear to the accused person is to send him to judicial custody and give him adequate time to consider whether he should make a confession at all. It would naturally be difficult to lay down any hard and fast rule as to the time which should be allowed to an accused person in any given case. However, speaking generally, it would, we think, be reasonable to insist upon giving an accused person at least 24 hours.
According to the learned trial court, huh?
Only 20-30 minutes.
Ought to have given at least 24 hours.
24 hours, and should have sent the accused to judicial custody because they were produced from police custody. To decide whether or not he should make confession,
Yes.
where there may be reason to suspect the accused has been persuaded or coerced to make a confession. Even longer period may have to be given to him before his statement is recorded. In our opinion, in the circumstances of this case, it is impossible to accept the view that enough time was given to the accused. So this is about confessional statements and the voluntary nature of the confession. Goes on, no discussions about confessional statements. Then 209. This is the finding of the trial court worship at page 209. Has the worship got page 209?
Yes.
Coming back to our case PW9, learner JMFC, deposed that she remember taking accused Imran to record his statement on 28 and 29, 605 in the court of JMC Kohima. He was lodged at South PS Kohima. The Lordship may kindly see, he was in police custody. At the time of confession statement was recorded on 28 and 29, 65. PW14 deposed to say that it is correct to say that I had taken accused Sapong from Vigilant Office to the court of JMFC for recording confession statement. I have also produced the case record in respect of accused Imna Samuel was recorded on 8605 and accused Achula and A. confession statement for JMC was recorded on 9605. Accused Sapong symptom on 15605, Tinawati on 13605, Imna Onan on 28605, and accused Imkan Lokma on 3605. I did not ascertain whether they were any police personnel outside the courtroom. I did not ascertain whether the accused Imna Onan was produced from judicial custody or police custody, since the case originated from vigilance. The accused Imna Onan was produced in my court for recording his statement. And in her cross-examination, it is correct to say that the accused was brought before me in the first office hour, and I gave him about 20 to 30 minutes for cool reflection. During the period of cool reflection, I have put the accused outside my courtroom, but I do not know where he spent the time. I agree that 20 to 30 minutes time is good enough for cool reflection. And from the deposition statement made by the JMFC, this court, it is clear to conclude that the accused were produced from police custody. So this is the finding of the trial court. They were produced from police custody. And on the day of production, after given only 20 to 30 minutes or so, JMFC reported the confessional statement of the accused persons in contrary to application of section 164 of CRPC. When accused is produced for recording confessional statement, JMFC has apprised the accused about the prayer made by the IO of the case and has to be sent back to judicial custody, giving at least 24 hours for proper reflection by the accused, as observed in Lawrence and Nathan case. And the same was found absent in the present given case, as the JMFC, after giving only 20 to 30 minutes or so, and on the same day of the accused production before JMFC, without ascertaining from whose custody the accused were produced, recorded the confessional statement of the accused persons, were recorded, and given in such given facts and circumstances, the same cannot be relied upon by this court as correct proposition and interpretation of section 164 of CRPC as interpreted above. So the lower trial court has also rejected the confession, their lordship. Your lordship?
Yes.
The confessional statements have been rejected by lower trial court.
Yes, yes.
And your lordship will recall, in my case, the R2, time for full reflection was given to him in the room of the prosecuting inspector. Your lordship has already noted that. Then next paragraph was about 313. Then ultimately, the order of the lower trial court. Now, as far as dominion over property is concerned, your lordship, 409, lordship, the witnesses of the NPSC who deposed that the persons who were in charge of the confession branch was someone else and not the number 2. That your lordship will see in statement of the witnesses of the NPSC. PW1, page 257. 257.
Yes.
This page is not very clear. 257. Then 258. Both statements are relevant. 258 is 257 is one LDA in the office of the NPSC.
Not clear.
Not clear at all. And 258.
PW2.
Yes, your lordship. This is also another LD. LDA. He was then serving as an undersecretary in the NPSC lordship, and he says,
Page 258.
In that, not very clear, lordship, in that particular point of time.
Just read it. I cannot read it.
Yes, your lordship.
It's not clear.
It's in the middle of the page. In that particular point of time, KV Legacy was a controller of examination who has created the post as controller of examination. Until now, he is holding the post of controller of examination. Usually, the answer scripts, mark sheets were kept in control of examination. And after completing the entries, the tabulation register issued to this office rule and collect the register and making all entries, the marks, interview report, and hand it over to the controller of examination in his chapter. even the typing is a little wrong, but records maintained by the controller of examination. Then in the cross selection, first is a little more clearer at the bottom of the page. The process of calculation of marks of candidates are as follows. The answer scripts of written examination along with the mark sheets are issued from the examiners by the NPSC. The said answer script and mark sheet are scrutinized by the chairman, members of the NPSC, and the secretary for areas, if any. Thereafter, the marks secured by the candidates are entered into a tabulation register by the. So there is an allegation that the tabulation register was also seized. That's why. After which it is submitted for approval to the secretary of the NPSC as well as the chairman and member of the NPSC, as the case may be with the appointment of the controller. The tabulation register is now being kept at the custody of the servants. So tabulation register is in the custody of the controller of examination. Controller of examinations is not an accused in this case. After declaration of written examination results, the viva voce is conducted by the NPSC. After the conduct of the viva voce examination with marks secured in the said examination, it is sent to. Thereafter, the marks secured by the candidates as well as the viva voce are entered by me. So this is the other secretary at that point of time in the tabulation register of eligible people. After this, the tabulation sheet and interview report is submitted to the chairman, member of the secretary in NPSC. Thereafter, in March with their approval, the results are declared. After the declaration of the result, the records are kept with me. This duty I performed till the year 2003 or 2004, beginning from 1981, after the appointment of controller of examinations in the year 2001 or 2002. This duty is now being performed by him, and he was already in office with the case of Supervisor Ms. Petitioner Kohima came to light. It is true tabulation many persons are involved, beginning from chairman and member secretary to secretaries and officials of the commission, as well as such other staff whom the secretary may entrust. I was examined by one deputy superintendent of police on 1805 and anti-corruption police station. I cannot say as to whether it would be possible for ascertaining in a tabulation register sheets to correct errors. The handwriting mark tabulation sheet referred to my sheet was shown to me by the DSP, namely Shioto Otsa. I cannot remember exactly where the police told me that the handwriting marks tabulation sheet was seized from the residence of Mrs. Takashira. I personally do not know whether the handwriting marks tabulation deeds were seized from the residence of Mrs. Takashira by the police. It is correct that the tabulation process, many persons are involved, beginning from the chairman to the dealing assistant and other staff of commission. However, I cannot say that it could be of any of those persons mentioned induced in the manipulation of the mark sheets as alleged in this case. I am not a handwriting expert. The mark sheet and the handwriting mark tabulation sheet have not been produced for my examination report. So basically, Your Worship, with respect to the tabulation register, in the custody of the controller of examinations. Controller of examinations, not an accused instance. So, Your Worship, just to conclude, and I place some authorities for Your Worship's consideration. Firstly, again, as I was saying earlier, Your Worship, confessional statements invalid, not confessional statements in the eye of law. Secondly, confessional statements have been retracted. And in fact, Your Worship, before that, I have taken steps to retract my confession of the previous one. In my list of papers which I submitted for inclusion in paper book, I made this application for retraction, but it has not been included. If I may be permitted to finish a copy. This is 25/209, much before the conclusion of the trial, before the examination of 313. May I read now? This is filed on 25/209. Worship may see on top. That the applicant is one of the accused in the Gauhati case. The applicant was arrested by the Vigilance Police Station on 2605 on allegations made by the said police. The applicant accused was put under various provisions of law for alleged offences committed by him. That after his arrest, the applicant accused was in police custody, that is in the custody of the Vigilance Police. Whilst in custody, the applicant accused was subjected to intense threats, coercion, and undue influence. He was repeatedly told to confess to the commission of the alleged offences and warned that dire consequences if he failed to do so. With the aim of securing a confessional statement, he was also told to
When your this statement is recorded,
No, Your Worship, I submitted this application.
No. The statement was recorded on which date?
My statement was recorded on, Your Worship, on two dates, 28/6/05 and 29/6/05.
Five, 2005.
2005.
Hmm.
2005. The case concluded only in the year 2016. Paragraph 3, that after being handed over to judicial custody on 28/6/05, two police officers from the Vigilance Police, namely May Onan and Shiotu. So these are the assistant investigating officers. Both then DSPs took the applicant accused from jail and produced him before the judicial magistrate first class. The applicant accused was threatened with the infliction of corporal punishment and electric shocks if he did not confess. Fearing for his life, the applicant accused was made to confess and append his signature on some documents. The confession was not voluntary, but at the instance of the police officers. The applicant accused was also not given any.
When you were arrested?
Arrested. Sometime in 2005, about it. The FIR was 27/5/2005. 27/5/2005.
No, that
Sometime
cannot be.
27/5/05.
175.
The FIR is dated 27/5/05. He was arrested on 26/05. I mentioned it in my first paragraph. 26/05. 26/05.
2605.
May I continue reading, my lord? The applicant accused was also not given any time to reflect before making the statement. After the recording of his statement, the said two police officers again took the applicant accused to their custody and kept him in the police lockup at South Police Station, Kohima. South Police Station, Kohima. That not being satisfied with the statement recorded in 28/6/05, the said two police officers continued their threats to the applicant accused and instructed him to make another confession statement. On 29/6/05, the said two police officers again took the applicant accused to court. This time he was produced before the EDCJ Kohima. So he was produced before another judicial officer and made to record another confession and send more documents. Here too, the confession was not voluntary, but at the instance of the police officers. As on an earlier day, the statement was recorded without allowing the applicant any time for reflection. After recording his confession, the two police officers took him to their custody, and from there he was transported to jail. Interestingly, both the confession statements are shown to be recorded by the same judicial officer. That the facts you said. So this is the application which I submitted for retraction of my confession statement. Now, Your Lordship, so firstly, not a valid confession statement. Secondly, a retracted confession statement. Thirdly, Your Lordship, in terms of the charge which is framed against the accused R2, no evidence has been led to establish the offense of 409. No evidence whatsoever, my lord. No evidence whatsoever. So if there is the principal charge which is framed against me, 409, 511 must also fail in respect of the accused R2. And R3, who is the father of R2, any prosecution against him is dependent upon the prosecution proving the charges against R2. Common intention, criminal consequences, attempt to commit offenses, Your Lordship. So when there is nothing which is proved against R2, nothing can be proved against R3. That, in sum and substance, is my case. Now, the authorities are wish to rely upon it.
There's no dispute that confession statement has been recorded and
In police custody.
it was retracted.
Yes, ma'am.
And it was delivered in police custody.
Yes, ma'am. And there is no dispute also that only 20-30 minutes. And there is no dispute also that the time for full reflection given to me was in the office of the prosecution inspector.
But not before the police,
Pardon me, Mother?
not before the police.
Uh,
Police have brought you to the court
yes,
and it was not before the police. Police was not there.
they brought me in their custody.
Hmm.
They brought me in their custody. And when the magistrate gave me time to reflect, she placed me in the room of the prosecution inspector. And as I've already observed, the prosecution inspector is also a part of the police establishment. And in court, it is his duty to see that all the prosecution's papers, the evidence of the prosecution is kept.
Therefore, it was not voluntary.
It was not voluntary job. Not voluntary. So firstly, Your Lordship, principles in relation to appeal against acquittal. The first one which I'm relying upon is 2008, 10 SCC. Your Lordship, I've given a list of authorities. In fact, list of authorities, it's for easy reference. 2008, 10 SCC, 450. Paragraph 69 and 70. At page 477. Your Lordship, got that? Page 477, paragraphs 69 and 70.
Yes.
Yes, 69. The following principles, after discussing all the case law, the following principles emerge from the cases above. One, the appellate court will review the evidence in the case against acquittal under section 378 and 386 of CRPC. Its power of reviewing evidence is wide, and the appellate court can reappreciate the entire evidence of the court. It can review the trial court's conclusions with respect to both facts and law. Two, the accused is presumed innocent until proven guilty. The accused possessed this presumption when he was before the trial court. The trial court's acquittal or bolsters the presumption that he is innocent. Three, due or proper weight and consideration must be given to the trial court's decision. This is especially true when a witness's credibility is at issue. It is not enough for the High Court to take a different view of the evidence. There must be substantial and compelling reasons for holding that the trial court was wrong. 17. In the light of the above, the High Court and other appellate courts should follow the well-settled principles crystallized by a number of judgments if it is going to overrule or otherwise disturb the trial court's acquittal. One, the appellate court may only overrule or otherwise disturb the trial court's acquittal if it has very substantial and compelling reasons for doing so. A number of instances arise in which the appellate court would have very substantial and compelling reasons to discard the trial court's decision. Very substantial and compelling reasons exist when, one, the trial court's conclusion with regard to the facts is palpably wrong. Two, trial court's decision was based on an erroneous view of law. Three, the trial court's judgment is likely to result in grave miscarriage of justice. Four, the entire approach of the trial court in dealing with the evidence was patently illegal. Five, the trial court's judgment was manifestly and unjustly unreasonable. Six, the trial court has ignored the evidence or misread the material evidence or has ignored material documents like dying declarations, report of the ballistic expert, etc. The list is intended to be illustrative, not exhaustive. So even this illustrative list, Your Lordship, none of these points fall in favor of the state appellate. Then the appellate court must always give proper weight and consideration to the findings of the trial court. Three, if two reasonable views can be reached, one that leads to acquittal, the other to conviction, the High Court appellate courts must rule in favor of the accused. But therefore, my Lord, my humble submission is that the approach of the trial court cannot be faulted.
According to her, the learned trial court has misread the evidence.
Yes.
Properly not been considered.
Yes.
That is what she is saying.
That is what she says.
Is it?
That is what the state says. But my case is, Your Lordship, the Illinois Trial Court has not disturbed the evidence. The Illinois Trial Court has acted in accordance with law. None of the points which have been listed here, though just illustrative, are met by the state indirectly. Then the next one, Your Lordship, is 2020-10 SEC 166. Paragraphs beginning from page 179, paragraph 14.
It's okay.
Same more or
You
less.
come to next one.
Same
Principle relating
Yes.
confessional statement.
Principles related to confessional statements. Then AR 1978, at page 1248, paragraph 22 and 42. 1254. Page 1254. Paragraphs 22 and 42.
20. 22.
Page- Page 1252, Your Lordship, not paragraph, not page 12, paragraph 22. The confession was retracted by the appellant when he was examined at the trial under 311 on June 14, 1975. It is well settled that a confession, if voluntarily and truthfully made, is an efficacious proof of guilt. Therefore, when in a capital case, the prosecution demands a conviction of the accused primarily on the basis of this confession recorded under section 164, the court must apply a double test, whether the confession was perfectly voluntary, if so, whether it is true and trustworthy. Satisfaction of the first test is the sine qua non for its admissibility in evidence. If the confession appears to the court to have been caused by any inducement, threat, or promise, such as is mentioned in section 24 Evidence Act, it must be excluded and rejected brevi mono. In such a case, the question of proceeding further to apply the second test is not apply. If the first test is satisfied with the court must, before acting upon the confession, reach the finding that what is stated therein is true and reliable. For judging the reliability of such a confession, or for that matter of any substantive piece of evidence, there is no rigid canon of universal application. Even so, one broad method which may be useful in most cases for evaluating a confession may be indicated. The court should carefully examine the confession and compare it with the rest of the evidence. In the light of the surrounding circumstances and probabilities of the case, if on such examination and comparison, the confession appears to be a probable catalog of events and naturally fits in with the rest of the evidence in the surrounding circumstances, it may be taken to have satisfied the second test. But therefore, Your Lordship, the first test is whether the confession was made perfectly voluntary. If that is satisfied, then only the second question comes into the picture. Then paragraph 24 and 42. Page 1257. It will be page 40, paragraph 42, page 1257.
Yes.
It will be seen that how much time for reflection should be allowed to an accused person before recording his confession is a question which depends on the circumstances of each case. The object of giving such time for reflection to the accused is to ensure that he is completely free from police influence. He must be completely free from police influence. If immediately before the recording of the confession, the accused was in judicial custody beyond the reach of the investigation of the police for some days, then such custody from its very nature may itself be a factor dispelling fear or influence of the police on the mind of the accused. In such a case, it may not be necessary to send back the accused person for any prolonged period to judicial or to jail or judicial lockup. In the instant case, the accused was got admitted to the judicial lockup on the 12th June for getting his confession recorded under section 164 CRPC, and such admission was made under the orders of the magistrate who ultimately recorded his confession on the 14th. So in our case, Your Lordship, there is no order after the accused was produced to record his confession. There is no order of the magistrate placing him under judicial custody. The accused was about 2 days in judicial custody beyond the reach of the police. On June 13, 1974, a written request was made to the magistrate by the police for recording the confession of the accused. Even then, the magistrate postponed the recording of the confession till the following day, obviously because he wanted to give the appellant 1 day more in judicial custody to ponder over the matter free from police influence.
No, it was, the evidence of IO says he's not in police custody.
He was in police custody. So,
He should be
free from police.
just being in the police custody. Will it be? Can it be presumed that it was under the duress or under
Yes,
force
Your
or
Lordship.
under threat?
Yes. Police custody is very different from judicial custody, Your Lordship.
Yes.
Police custody is.
The evidence clearly shows that he was in police custody.
So the court, the Supreme Court says it must be completely free from police influence. So
But
police custody.
it says it's free from police influence,
Yes, Your Lordship.
not just from the police custody.
That is what it means, Your Lordship. Police custody is police influence. Judicial custody is free from police influence. That is the fact that is what.
No, it's okay.
Yes.
In your case, he was in police
That is
custody.
police.
In the police custody, can we mean that it is under the influence of the police?
Yes, my lord. Yes, my lord.
Just because he is under the police custody.
Yes, my lord. His
Custody.
liberty is curtailed by the police officers around him. He's not a free person. He's not a free person, Your Lordship. Then the next one is 2007-12 SEC at 230. Page 270. Relevant paragraphs begin from page 270.
So many paragraphs. So many paragraphs. Just read the
Some are written
relevant
in-
one.
Beginning from page 109. So this is about retracted confessions. So 109, in case of retracted confession, the courts when arriving at a finding of guilt would not ordinarily rely solely thereupon and look forward for corroboration of material particulars. Such corroboration must not be referable in nature. Such corroboration must be independent and conclusive in nature. So along the same lines, 109, 1010, 1011, then 116, then 125, then what should come to 125, paragraph 125 at page 274. Page 274, paragraph 125. Effect of retracted confession. Page 125, paragraph 125.
Yes.
We are not suggesting that the confession was not true, but the question is what would be the effect of a retracted confession? It is now a well-settled principle of law that a retracted confession is a weak evidence. The court, by relying on such retracted confession, must satisfy itself with the same as truthful and trustworthy. Evidences brought on record by way of judicial confession, which should retracted, should be substantially corroborated by other independent and cogent evidences, which would lead adequate assurance, which would lend adequate assurance to the court that it may seek to rely thereupon. And 126 on the same lines. Then the next one, Your Lordship. 2002-8 SCC at page 73, beginning from page 76.
If there are evidences corroborating it, then even if it is retracted, can be
relied upon.
relied upon.
Yes. Then beginning from paragraph 10. Check at page 76.
Yes.
According to the deposition of PwC in the cross-examination, the accused were in police custody 18 to 20 days prior to recording of the confession statement. PwC has deposed that he gave the requisite warning to the accused that they were not bound to make the confession statement, and if they make it, will be used as evidence against. But despite the warning, they were prepared and willing to make this. After recording the introductory statement in this behalf, in question answer form, he still considered it proper to give them some time for rethinking, and for this purpose, they were allowed to sit in the circuit room for some time and were brought to him. after about half an hour and expressed a desire to make statement and thereafter record the professional statements. And 11, before adverting to the facts said to have been narrated by the accused as reported in two confessional statements, it deserves to be noticed that in case the recording officer of a confessional statement on administrating the statutory warning to the accused forms a belief that the accused should be granted some time to think over the matter, it becomes obligatory on him to grant reasonable time for the purpose to the accused. In other words, the cooling time that is granted has to be reasonable. What time should be granted will of course depend upon the facts and circumstances of each case. At the same time, however, when the time to think over is granted, it cannot be a mere fast for the sake of granting time. In a given case, depending on facts, the recording officer, without granting any time, may straightaway proceed to record the confessional statement, but if he thinks it appropriate to grant time, it cannot be a mechanical exercise for completing a formality. So this is about the NDPS, the police, the confession to a police officer. Then 12, in the earlier case which we refer to, Your Lordship, versus the state of Punjab, where a magistrate granted about half an hour to the accused to think over and soon thereafter recorded the confession statement. This court reiterated that when an accused is produced before the magistrate by the investigating officer, it is of utmost importance that the mind of the accused person should be completely freed from any possible influence of the police, and the effective way of securing such freedom from fear to the accused person is to send him to jail custody. So this is precisely the point, Your Lordship, and give him adequate time to consider whether he should make a confession at all. It would naturally be difficult to lay down any hard and fast rule as to what time should be allowed to an accused person in any given case. 13, this court held. However, speaking generally, we think this is the same case, Your Lordship. We think it reasonable to insist upon giving an accused person at least 24 hours to decide whether or not he should make a confession, where there may be reason to suspect that the accused has been persuaded or coerced to make a confession. Even longer period may have to be given to him before his statement is recorded. In our opinion, the circumstances of the case, it is impossible to accept the view that enough time was given to the accused to think over the matter. Then paragraph 20. Paragraph 20, in the fact and circumstances of the present case, the grant of half an hour to the accused to think over before recording the confessional statements cannot be held to be a reasonable period. We do not think that it is safe to base a conviction on such confessional statements. So 20-30 minutes, half an hour here. And so produced from police custody must be sent to judicial custody, jail custody. Now, last point I mentioned about the diary. This is the Navala case I mentioned. This is 1998, 3 SSC 410. And this has also been taken into consideration by the United Trial Court. Paragraphs 34 to 39. At page 431. 432. From paragraph 34 onwards, my lord, at page 432.
Yes.
Paragraph 34. The rationale behind admissibility of parties' books of accounts as evidence is that the irregularity of habit, the difficulty of falsification, and the fair certainty of ultimate detection give them in a different degree the possibility of trustworthiness. Since, however, an element of self-interest and partisanship of the entrant to make a person behind whose back and about whose knowledge the entry is made liable cannot be ruled out, and additional safeguard of insistence upon other independent evidence to fasten him with such liability has been provided for before by incorporating the words, such statements shall not alone be sufficient to charge any person with liability. So this is about the Hawala diaries, and this principle is elaborated from paragraphs 34 to 39. And this has been taken into consideration by the United Trial Court. So this is my case. The first and foremost solution at the cost of repetition. The charge under which I was framed, section 409. That is the main section. If section 409 fails, everything else fails. As far as I'm concerned. No evidence whatsoever there to show in what manner I was placed over dominion over property. No evidence at all, nothing at all. That is my case. So my humble prayer is that the bill is without merit and lies for the business. Watch it.
Lordship, the learned senior counsel has covered all aspects of the case.
Same section,
Your Lordship,
same offense, same section.
109, criminal conspiracy, Your Lordship, and then 511.
511.
34.
34.
Yes, and the allegation against me is
No
that-
409.
No, Your Lordship, I'll take Your Lordship to the. Third sheet. Page 332. Page 34, that is command intention, 109 and 511.
Page,
Page 332. Page 332. Your Lordship. 332.
Yes. You are for respondent?
I am the respondent number 1. Your Lordship.
Who are you?
G. Santam, Sapong C. Santam, Your Lordship. Respondent number 1.
Is a government servant? No,
Your Lordship?
government servant.
No, he is not. He is not. So appointment and attempt, Your Lordship.
What is your role?
The case against me is that I paid a certain amount to the respondent number 2. That is
By way of loan?
Your
no.
Lordship, not by way of,
To purchase the,
that is the case, yes, that is
to purchase the,
that
for
is-
purchasing of
yes,
papers.
that is the accusation against me.
Have you got it? For your daughter? For your
No,
son
for
or
myself.
for yourself?
For myself, that is,
Okay.
that is the.
Where are you now?
He is still unemployed,
Okay,
he is still unemployed,
you will be able, obviously,
so, yes.
if you attempt to purchase the papers, how you will be employed? Off the record, huh?
So essentially, the case that the learned senior counsel has submitted, it covers everything.
Everything.
It was retracted.
You had up.
He was,
And of course, appeal against them are common, not particular accused,
yes.
For all of them.
all of them. It's a common thing only, general ground, nothing specific, I mean, particular about particular accused, isn't it?
Yes, for all the accused.
Appears to have filed the appeal for the sake of filing,
No,
not by you, by the state, not as a vis as a state of Nagaland. Is it? I'm just unlettered. Okay. Same. So I would request to submit a written submission It will be short so far as your submission is maybe voluminous. They say the court has to examine. Will examine on the basis of your submission.
Lordship, earlier you
So
were.
there is no strategic formula,
Okay.
even by the apex court. It depends on facts and circumstances,
yes.
and you have to examine the records, and then on that basis only, even if it is restricted, if there is a supporting evidence can be relied on. That is the law. So I would request you to, all of you, file the written submission.
Lordship, earlier you
Or
were.
there is no question of, you are not frame for in case. Of course, you have not pleaded also. There is no question of retrial also. You are not, you have not pleaded. Either to convict or to
Yes.
dismiss.
But on the face of it, on the face of it, when we start against me, we have not proceeded against her at all. There is no case at all. Suppose you and I, not saying, that's not saying. Here we are talking about, military. We are arguing about tutorials. On the face of it.
Will examine, I'll go through it. And when can you file the written submission? I have recorded the submission, but then since tomorrow you may say that whatever I have, argued before the court, it has not been recorded. You may say so. And it's convenient for the court also if you file the written submission. At least on the facts and the submission you make, so we can record it. So it's convenient for the court also. When can you? No issue. By Monday?
Monday will be too early.
Will not list the matter unnecessary. You file, you submit here also. Bench assistant. Huh? Hard mistake. Bishop London Public Prosecutor for the state. Also had Azimomi Land Council for respond number 2 and 3. One is T. Tampo Pangana Land Council for 1, respond number 1.
So I'm for respond number 6.
Azimomi for respond number 2 and 3. And Lima Bapam for respond number 6. What about the others? Notice, sir, all of them.
Yes, everything, your lordship, if I'm not, because it's an old case, your lordship, otherwise, if I'm not mistaken, notice everything was completed and one council, if I'm correct, represented before, so for the other respondents.
It's all subject.
Yes.
Now, of course, we have concluded.
Yes, everything was completed, your lordship, the notice. Yes.
We'll say on non-appearance for rest of the thing. 5, 7 and 8. Non-appearance for respond number 5, 7 and 8. You are for 6, right? 4 has been strike off. I mean, it's got a better.
No, 7 and 8. Yes.
5, 7, 8.
1, 2, 3. You are for 6, 5, 7 and 8 only. 5, 7 and 8. Hearing completed. CAB. Huh? Will not record the written submission.
Okay.
By Monday, you may submit the
Okay,
respective written submission. Along with, you annex those
Yes.
judgment also.
Yes, earlier.
Because if there are, multiple layers, it's very difficult.
Lordship, earlier you were asking whether the prosecution witness number 9, as well as
Yes,
the
yes.
other one, the same person, it's a typing mistake made by the registry.
Okay.
Otherwise, from the record, it's prosecution witness number 10. Yes. So his
Yeah.
deposition was taken on 2 occasions, 4th April and 4th April and 16 March.
okay.
Yes, yes. Otherwise, it's
It should be 10 only,
Yes.
not the 9.
yes.
9 is a 9,
Nine is the
other 9 is
magistrate.
the magistrate.
Yes,
no?
yes, yes.
This It's correct, Chair. Page, what was the page?
Page 269. Page 269 and 276.
276.
Yes.
269 is
It should be PW 10.
10, huh?
Yes, yes.
Then PW 10 and
276 is PW 10.
then 279 is whatever
276
276
PW 10.
PW 10
Yes,
and 269 is also PW
PW
10.
10, yes.
Yeah, okay.
The statements were recorded on 2 occasions.
Yes, yes.
Yes.
Okay. He's the IO.
Yes, yes, IO.
Okay. Huh? Are you ready?
My lord,
What is this?
this is revision petition directed against the order of the district judge, setting aside the injunction order granted by the trial court. That is the matter, my lord.
That's why civil revision.
Yes. My lord, the impugn order is at page 250, my lord. Two 250.
Let us see next week.
My lord.
Let us see next week.
26, then,
26.
26 is
26 Thursday. Tuesday. 26. Only prayer of London Council for the parties missed this matter on 26. Facts are long, but then issue is small.
Issue is small. And Lordship, this is a
Whether
revision.
the district judge was correct in
Yes, yes. And this is a revision, Lordship.
revision.
Actually, Lordship, if I may, they have filed this under section 115 of the CPC. Section 115 is no more available because of the amendment. Because if it was passed in their favor, the suit could not have been disposed of. It's against the rejection of the injunction, setting aside of the injunction. So section 115 of the CPC will not apply. Rule 32 has been mentioned. Our local rules. That also, Lordship, there's a Register General case of the High Court. 2013, they said CPC is applicable.
2013 for GLT 10.
Yes, yes. 2013. 2006.
102.
Now, therefore, this petition is a revision petition, so 227 only will be attracted.
So it's not maintainable according to
227 will be attracted. So since the source is there, this can be taken up as a petition under 227. But it will be a revision petition.
no, that has to be, that order has, for that also it has to be converted.
It has to be converted.
You will have to pass an order. You think about this issue, because these are all for all of us.
Yes.
Procedural aspect. Huh? We'll hear you on that 26.
Amen.
Yes, Your Lordship.
Yes,
Your Lordship, I'm mentioning on behalf of the leading counsel for the petitioner.
okay,
So kindly list this matter after.
after you wait.
Yes, Your Lordship.
You were, that day you said there's a urgency,
Yes, Your Lordship, it is as per the.
so
instruction of the leading
there's no
counsel.
urgency now.
That is how he has instructed.
On the prayer of MS Spencer, learned counsel for the petition, list this matter after a week.
Deeply obliged.